Have you ever heard of someone suing a restaurant because their coffee was too hot? Or taking a company to court over a snack that didn't make them lose weight as advertised? In America, the land of opportunity extends far beyond just business and dreams. It reaches right into the courtroom, where practically anyone can sue for practically anything, no matter how bizarre or unbelievable the claim might sound. This isn't just theoretical, it's a real and often jaw-dropping part of our legal landscape, where common sense sometimes takes a backseat to creative interpretations of justice. Today, we're diving headfirst into that world of legal absurdity, counting down 33 of the most ridiculous lawsuits that actually made it to court in the United States. From cases that defy logic to claims that border on parody, these stories highlight the quirks and sometimes outright chaos of a justice system that allows for unparalleled access for better or for worse. You'll find yourself shaking your head in disbelief, maybe even laughing out loud, as we explore how the pursuit of justice can sometimes veer into the territory of pure comedy. But beyond the humor, there's a fascinating layer to these tales, a reflection of American culture, our relationship with responsibility, and how the law adapts or doesn't to human creativity. So whether you're a legal enthusiast, someone who loves a good story, or just curious about the outer limits of what people will argue in front of a judge, you're in for a treat. Sit back, relax, and get ready to explore some of the most unforgettable, mind-boggling legal battles ever filed. Let's begin the countdown. And so we kick off our countdown with perhaps the most misunderstood and widely mocked lawsuit in American history, the legendary or perhaps infamous hot coffee case. In 1992, 79-year-old Stella Liebeck was a passenger in her grandson's car at a McDonald's drive-thru in Albuquerque, New Mexico. After purchasing a cup of coffee, she placed it between her knees to remove the lid and add cream and sugar. In a tragic split second, the entire cup spilled onto her lap. Now, the immediate public reaction, fueled by sensational headlines, was one of sheer ridicule. The idea of suing a company because coffee, a famously hot beverage, was hot seemed to be the ultimate example of frivolous litigation, a sign of a society gone mad with blaming others for personal clumsiness. But the truth, as revealed in the courtroom, was far more disturbing and complex than the simplistic punchline it became. This wasn't a minor scalding. Stella Liebeck suffered third-degree burns over 6% of her body, including her inner thighs, groin, and buttocks. She was hospitalized for 8 days and had to undergo agonizing skin graft surgeries. Her medical bills were substantial. During the trial, a startling fact emerged. McDonald's corporate policy was to serve its coffee at a temperature between 180 and 190 degrees Fahrenheit. That's significantly hotter than coffee brewed at home, which is typically around 135 to 140 degrees. At 190 degrees, a liquid can cause third-degree burns in under 3 seconds. The company's own quality control manager testified that they were aware of this risk, acknowledging that coffee served at that temperature was not fit for consumption because it would burn the mouth and throat. Most damningly, the jury learned that in the decade prior to this incident, McDonald's had received over 700 reports of people burning themselves, some with severe injuries, and had paid out previous settlements. Yet, they had made a conscious business decision not to lower the temperature, arguing that extreme heat kept coffee tasting fresh longer in their pots. The jury was not just awarding compensation for Stella's medical bills and pain. They were sending a massive message. They found McDonald's guilty of gross negligence and awarded $200,000 in compensatory damages, which was reduced to $160,000 due to the jury finding Stella 20% at fault for the spill. But then, they added a staggering $2.7 million in punitive damages, a sum calculated to be equivalent to about 2 days of McDonald's coffee sales. This wasn't about a spilled drink. It was about a corporation knowingly putting customers at risk for profit and ignoring hundreds of prior warnings. The judge later reduced that punitive award to $480,000, and the case was eventually settled out of court for an undisclosed amount, believed to be less than that. While the case became a cultural shorthand for lawsuit abuse, a closer look reveals it was actually a powerful example of the system holding a powerful entity accountable for a conscious, dangerous choice. If the McDonald's case was a serious matter disguised as a joke, our next lawsuit flipped that script entirely. It was a joke that somehow became a deadly serious and astronomically expensive legal battle. In 2005, a Washington, D.C. administrative law judge named Roy Pearson decided to take his local dry cleaners, Jin and Sue Chung, to court. The reason: a lost pair of suit pants. The demanded compensation: a cool $67 million. The saga began simply enough. Pearson brought several suits to custom cleaners for alterations. When he returned to pick them up, he claimed one pair of gray trousers was missing. The Chungs, a hard-working immigrant family who had built their small business from the ground up, located what they believed were the pants in question. Pearson, however, insisted they were not his, alleging the belt loops were wrong. Despite their best efforts to resolve the issue, including offering to pay the full cost of the pants, which was around $1,000, Pearson refused to drop the matter. He was not interested in a simple reimbursement. He was about to launch a legal crusade that would defy all logic. Pearson's claim was built around the store's signage, which prominently featured a promise: satisfaction guaranteed. In his interpretation, this wasn't a simple pledge of good service. It was an unconditional, ironclad warranty that covered every single customer transaction for all time. He argued that the lost pants represented a fundamental breach of this guarantee. But how did a dispute over trousers balloon into a multi-million-dollar claim? Pearson's own calculations were a masterpiece of legal absurdity. He tallied up the potential violations, claiming the Chungs owed every customer who had ever been dissatisfied a penalty, and then added on his own personal costs for renting a car every weekend for a decade to drive to a different dry cleaner. The $67 million figure was, by any reasonable standard, pure fantasy. The case quickly became a media sensation, a perfect symbol of a legal system that seemed to have lost its mind. It was relentlessly mocked on television, in newspapers, and around water coolers nationwide. For the Chungs, however, the laughter of the public was little comfort. They were facing financial ruin from the sheer cost of defending themselves against a claim that was both vicious and utterly frivolous. They spent over $100,000 in legal fees, a massive sum for a small family operation, and the stress took an immense emotional and physical toll. After a lengthy trial that scrutinized every detail of the case, including the dramatic moment the missing pants were produced in court and were almost certainly Pearson's, as evidenced by his own identification on the receipt, the judge ruled decisively. He found for the defendants, the Chungs, on every single count, calling Pearson's arguments unreasonable and illogical. The judge even awarded the dry cleaners' court costs, a small but symbolic victory. Though they won the case, the Chungs' ordeal highlighted a terrifying flaw in the system: the ability of a single, relentless individual to weaponize the courts and bring a devastating, costly fight to someone's doorstep over the most trivial of grievances. Roy Pearson's pants became more than an article of clothing. They became a lasting symbol of how a promise of satisfaction can be twisted into a tool of absurdity and oppression. Our next case proves that when it comes to imaginative legal claims, sometimes the most compelling evidence is the evidence you simply cannot see. In 2011, a cable technician in Pennsylvania found herself at the center of a lawsuit that seemed to be pulled directly from a cartoon. The woman was performing a routine installation at a private home when she allegedly tripped and fell in the customer's yard. the cause of her stumble, according to the subsequent lawsuit she filed against the cable company and the homeowner. An invisible dog leash. That's right, the legal claim hinged on the existence of a leash for a dog that was not physically present, a tether made of nothing but air and presumably a great deal of creativity. The technician argued that the homeowner was negligent for creating a hidden hazard on the property, a trap that no reasonable person could have anticipated or seen. The case immediately entered the realm of legal legend, not for its profound implications but for its sheer head-scratching absurdity. How does one prove an invisible leash exists? How does a defendant disprove it? The entire premise seemed to challenge the very foundation of evidence-based law. Legally, the case fell under the concept of premises liability, which holds property owners responsible for maintaining a safe environment for visitors. For such a claim to be successful, the injured party typically must prove the owner knew or should have known about a dangerous condition and failed to address it. But this case turned that notion on its head. The homeowner would have had to either admit to the bizarre practice of tying up an invisible dog or somehow be held accountable for a hazard that, by its very definition, left no trace and could not be documented. The cable company, also named in the suit, found itself in the equally bizarre position of having to defend its employees' encounter with a phantom object. Unsurprisingly, the case didn't exactly have legs, visible or otherwise. A judge swiftly dismissed the lawsuit, pointing out the complete and total lack of any factual evidence to support the extraordinary claim. There were no witnesses to the invisible leash, no photographs of the vacant spot where it supposedly lay, and certainly no physical leash to enter into evidence. The ruling was a clear affirmation that while the American legal system is open to all sorts of claims, it still requires more than just a tall tale and an injury to hold someone liable. This case serves as a perfect, if extreme, example of the line between a genuine accident and a fabricated story designed to pin blame and secure a payout. It was a lawsuit that asked the court to take a leap of faith so large, not even an invisible leash could have tripped it up. Moving from the surreal realm of invisible hazards, we arrive at a case that delves into something even more intangible: the human soul and the desperate, costly hope of reaching beyond the grave. Our fourth lawsuit takes us into the world of the supernatural, where a woman's profound grief was met with promises that were, legally speaking, out of this world. In 2005, a woman named Cynthia Allison filed a lawsuit against a psychic named Priscilla Del Maro, alleging massive fraud. The claim was as straightforward as it was heartbreaking. The psychic had taken over $20,000 from Allison, promising to use her spiritual powers to reunite her with her deceased husband. Not in a metaphorical sense, but to literally bring him back to life. The story begins with Cynthia Allison, a woman utterly devastated by the loss of her husband. In her state of vulnerability and sorrow, she sought out Priscilla Del Maro, who claimed to have the ability to communicate with the dead. What started as readings and seances quickly escalated. Del Maro allegedly convinced Allison that not only could she speak to her husband, but that she could also orchestrate his full resurrection. For this miraculous service, the psychic demanded increasingly large sums of money, eventually accumulating to more than $20,000. Payments were justified for a variety of mystical expenses, from purchasing special candles and crystals to, allegedly, even buying a new car that was somehow spiritually necessary for the resurrection ritual. When, predictably, Allison's husband did not return, she came to the crushing realization that she had been financially exploited at a most emotionally fragile moment, and she took the psychic to court for fraud. The legal battle that followed was a fascinating clash between the material world of the law and the ethereal world of the supernatural. To win a fraud case, a plaintiff must generally prove that the defendant made a false statement of fact, knew it was false, made it with the intention of deceiving the victim, and that the victim suffered a loss by relying on that false statement. The monumental challenge for Allison and her lawyers was proving in a court of law that psychic powers do not exist. How do you provide evidence that someone cannot communicate with the dead or perform miracles? The defense argued that claims of psychic ability are statements of belief or opinion, protected under the First Amendment's guarantee of free speech. They contended that selling spiritual guidance or hopeful predictions is no different from a religion selling the promise of an afterlife. It's a matter of faith, not a verifiable fact that can be proven true or false in a courtroom. The court ultimately agreed with this defense. The judge dismissed the case, ruling that the psychic's promises were protected under the First Amendment. The decision highlighted a crucial legal loophole. While the court could address the exchange of money for services, it could not adjudicate the truth or falsity of religious or spiritual beliefs. This created a shield for psychics, mediums, and fortune tellers, allowing them to operate in a space where customer satisfaction is based on faith rather than measurable results. For Cynthia Allison, the ruling was a final blow, a legal confirmation that her significant financial loss and deepened emotional anguish had no recourse. The public's reaction to the case was a mix of sympathy for her grief and astonishment at the sheer literalness of her expectation. It sparked widespread debate about the regulation of psychic services and the fine line between offering comfort to the bereaved and preying on them. This case stands as a stark reminder of the limits of the legal system and the powerful, sometimes dangerous, intersection of hope, belief, and exploitation. But after grappling with the supernatural, our next lawsuit brings us back to the cold, hard reality of a fast food counter, where the stakes were not eternal life, but the exact dimensions of a hamburger. In 2017, a Florida man named Michael Krakauer decided to take on the fast food giant Burger King, filing a class action lawsuit that accused the company of a very specific form of deception. His claims centered on the advertising for the chain's signature sandwich, the Whopper. Krakauer argued that the posters and menu boards depicted a burger that was larger, juicier, and altogether more magnificent than the one he actually received. The patty, he alleged, did not overflow the bun, the vegetables looked less plentiful, and crucially, the overall sandwich fell short of the advertised 7-inch promise. This discrepancy, the suit claimed, amounted to false advertising and caused him, along with other customers, to suffer actual monetary loss and emotional distress. This case immediately plunged into the complex and often murky world of advertising law, particularly the legal concept of puffery. Puffery is defined as an exaggerated, blustering, or boasting statement that no reasonable person would accept as a literal fact. It's subjective, non-measurable hype that is legally allowed because it's considered harmless sales talk. Think of a pizza place claiming they have the best pizza in the world, or a car commercial showing a vehicle effortlessly climbing a mountain. Courts recognize that consumers understand this is exaggeration for effect, not a concrete guarantee. Burger King's defense rested squarely on this principle. They argued that the images of their burgers, with perfect ingredients artistically arranged and dripping with condiments, were obviously idealized representations meant to make the product look appealing, not a binding contract specifying the exact volume of mayonnaise or the precise alignment of pickle slices. The 7-inch claim added a slightly more tangible element, but it was quickly dismantled. The advertised length refers to the diameter of the bun before it is warmed and placed around the burger patty and toppings. The warm, soft bun naturally compresses, and the overall height and width of the finished product will understandably be less. The court found that no reasonable consumer would expect to receive a flat, rigid, 7-inch wide disc of a sandwich. The context made the claim's meaning clear. Furthermore, the judge pointed out the sheer impracticality of the lawsuit. The Whopper is a low-cost, mass-produced item served in minutes. The idea that a customer suffers genuine, emotional distress from a burger being marginally smaller than a marketing image was viewed as a dramatic overreach. trivializing the legal concept of emotional harm, which is typically reserved for severe psychological trauma. The case was dismissed with prejudice, meaning it could not be refiled. In his ruling, the judge effectively labeled the lawsuit as frivolous, a wasteful clogging of the judicial system with a grievance that belonged in the court of public opinion, not a court of law. For the public, the case became a punchline, another example of litigation culture run amok. But for the fast food industry and marketing professionals, it was a reaffirmation of the broad protections afforded to advertising puffery. It underscored that while businesses cannot tell outright lies about their products, claiming a burger is made of grass-fed beef when it is not. For example, they have wide latitude to make their goods look as delicious as possible, even if that reality is a bit messier and less photogenic when it's handed to you through a drive-through window. The Whopper lawsuit, in the end, was less about a missing inch and more about the vast gap between marketing fantasy and everyday reality. Leaving behind the world of misleading burgers, we arrive at a case that pits personal responsibility against the duties of an establishment in a high-stakes environment, the casino floor. Our sixth lawsuit takes us to Atlantic City, where in 2007, a gambler named A.J. Gambella decided to sue the Trump Taj Mahal casino after a disastrous night of poker. His claim was not that the games were rigged or that he was cheated. Instead, he argued that the casino was legally negligent for allowing him to continue gambling and losing while he was visibly intoxicated. After dropping a staggering $122,000, he turned to the courts, seeking to recoup his losses by arguing the casino had a duty to protect him from his own impaired judgment. Gambella's lawsuit painted a picture of a man who was not in control of his faculties. He claimed that casino staff plied him with free alcohol for hours, leading to a state of severe intoxication where he could no longer make rational decisions about his bets. His legal argument hinged on a concept known as dram shop liability, which typically holds bars and restaurants accountable for serving alcohol to visibly intoxicated patrons who then go on to cause harm, such as a drunk driving accident. Gambella's lawyers creatively tried to apply this principle to a casino, arguing that the establishment had a similar duty to stop serving him drinks and, more importantly, to stop accepting his money at the poker table once he was clearly drunk. He wasn't just suing for the price of the alcohol, he was suing for the entire amount he lost while under its influence. The case forced the court to wrestle with a fundamental question: where does an establishment's responsibility to act ethically end, and an individual's responsibility for their own choices begin? The casino argued that Gambella was a voluntary participant who chose to drink and chose to gamble. They pointed out that he was a seasoned poker player, not a novice being unfairly exploited. Furthermore, they contended that monitoring the sobriety of every single patron at a table game to determine if they were too drunk to make a wager would be an impossibly vague and burdensome standard. How drunk is too drunk to play cards? Is it a slight slur, a wobbly stance, or a bad bluff? Unlike a bartender who can cut someone off, a casino dealer's role isn't to be a financial babysitter. The court's ruling was a resounding affirmation of personal accountability. The judge dismissed the lawsuit, stating that a casino has no legal duty to stop a patron from gambling simply because they are intoxicated. The court recognized that adults are ultimately responsible for their own actions, including the decision to consume alcohol and then risk money. To rule otherwise, the judge suggested, would create a bizarre precedent where individuals could abdicate all responsibility for their choices the moment they had a drink, turning casinos into insurers against bad luck and poor judgment. The decision highlighted the absurdity of the claim, the idea that a business could be penalized for allowing a customer to do exactly what he came there to do. This case serves as a powerful counterpoint to lawsuits where businesses are rightly held accountable for genuine external dangers, like the scalding coffee at McDonald's. Here, the hazard was entirely internal. It was the gambler's own impaired state, a condition he willingly entered into. The public reaction was overwhelmingly unsympathetic, viewing the case as the ultimate example of trying to blame others for one's own mistakes. It underscored a cultural expectation that, especially in the adult world of gambling, you have to be willing to shoulder the consequences of your actions, whether you're on a winning streak or a catastrophic losing one. The house may always have the edge, but that doesn't mean it's responsible for holding your hand when you decide to play. If you thought suing over a psychic's failed resurrection was a stretch, our next case launches us straight into the stratosphere of legal impossibility. We arrive at what might be the most literally far-fetched lawsuit on our list, the case of the alien abductees who tried to sue the United States government. In the early 1990s, a couple from Brooklyn, New York, filed a $20 billion lawsuit against the federal government, specifically naming the National Aeronautics and Space Administration and the Defense Intelligence Agency. Their extraordinary claim was that the U.S. government had failed in its constitutional duty to protect them from repeated abductions by extraterrestrial beings. They sought damages for the severe emotional trauma and distress caused by these otherworldly encounters, arguing that the state's negligence had allowed these violations to continue unabated. The plaintiffs, a man and a woman, described in detail their experiences of being taken aboard alien spacecraft, subjected to medical examinations and used for unexplained experiments. They claimed these events were not isolated incidents but part of a persistent pattern of harassment by intelligent life from beyond our planet. Their legal filing was a surreal document, reading more like a science fiction screenplay than a standard court complaint. It laid out a narrative of personal violation on an interstellar scale, alleging a profound failure of the government's most basic function, to provide for the common defense and ensure domestic tranquility. From their perspective, these abductions were a form of invasion, and the state's inability to stop them was a catastrophic dereliction of duty. Inside the courtroom, the atmosphere was a bizarre mix of solemn judicial procedure and utter incredulity. The judge faced an unprecedented legal quandary. How does a court, an institution grounded in evidence, precedent, and earthly jurisdiction, begin to process a claim about events that allegedly occurred in outer space or aboard non-human vessels? The government's defense was as simple as it was insurmountable. The claims were not just unproven, they were utterly unprovable and beyond the scope of any legal remedy the court could provide. Lawyers for the agencies argued that the court had no authority over extraterrestrial civilizations, if they even existed, and that holding the government liable for failing to prevent such encounters would require capabilities far beyond any current or foreseeable human technology. The case was dismissed, and rather swiftly. The judge's ruling highlighted several fundamental legal barriers. First, the doctrine of sovereign immunity generally protects the federal government from being sued unless it explicitly consents, and it certainly had not consented to be held liable for alien abductions. Second, and more profoundly, the court found there was no recognizable legal duty for the government to protect individual citizens from purported extraterrestrial beings. Establishing such a duty would have been a legal impossibility, as there is no statute, regulation, or case law in American jurisprudence that even acknowledges, let alone regulates, contact with intelligent alien life. The plaintiffs' claims were deemed non-justiciable, meaning they presented a political question far outside the competency and authority of the judicial branch to resolve. This lawsuit stands as the absolute extreme end of frivolous litigation based on supernatural or paranormal events. Unlike the psychic case, which involved a financial transaction between two people, this case attempted to hold a vast democratic institution accountable for forces that, by their very nature, defy all verification and exist outside the framework of reality that laws are designed to govern. It represents a complete breakdown of the line between a personal belief system and the functioning of the justice system. For the public, it was a source of amusement and bewilderment, a story that seemed to confirm every stereotype about runaway litigiousness. But on a deeper level, it serves as a perfect boundary marker for the legal system, demonstrating that while the courtroom doors are open to all sorts of grievances, they cannot open into realms that lack any anchor in fact, evidence, or established law. It was a case that asked the law to do the impossible to provide justice for an injustice that, by all measurable standards, the court could not confirm ever happened. Yet for all its otherworldly ambition, our next case brings us crashing back down to earth, to a grievance so personal and everyday it feels almost universal, a truly terrible haircut. In 2012, a woman named Denise Schneider sat down in a salon chair in Chicago and walked out with a haircut she claimed was so devastating it ruined her life. The stylist had cut her hair significantly shorter than she had requested, and Schneider's reaction was not just one of disappointment, but of profound psychological trauma. She filed a lawsuit against the salon and the stylist, seeking a stunning $2 million in damages for the severe emotional distress and humiliation the bad haircut had allegedly caused. Schneider's court filings painted a picture of a life unraveled. She claimed the botched hairstyle left her too embarrassed and depressed to leave her house, causing her to miss work and social events. She argued it triggered a deep emotional crisis, damaging her self-esteem and her ability to function in daily life. On its surface, the case seemed to tap into a relatable human fear, the vulnerability we feel when placing our personal appearance in someone else's hands. A bad haircut can feel like a personal violation, a forced change to our identity that we have to live with every day until it grows out. But the legal system is not designed to adjudicate matters of taste or personal disappointment, no matter how deeply felt. It requires proof of a legally recognized harm. This is where Schneider's case collided with the cold, hard standards of the law. To successfully sue for emotional distress, a plaintiff must typically clear a very high bar. There are generally two paths: proving negligent infliction of emotional distress, or the more severe, intentional infliction of emotional distress. For the negligent variety, which this case fell under, most courts require that the emotional distress be a direct result of some physical injury, or at the very least, be so severe that it manifests in physical symptoms. Think diagnosed anxiety, sleeplessness, or ulcers directly linked to the incident. A feeling of humiliation and a desire to stay home, while genuinely unpleasant, rarely meets this stringent standard. The stylist's mistake, even if professionally negligent, was not an act of intentional cruelty designed to cause psychological harm. It was, in the eyes of the law, a service not performed to the customer's satisfaction, a commercial dispute, not a tort worthy of millions. Unsurprisingly, the case was met with a tidal wave of media mockery. Headlines joked about split ends and lawsuits and bad hair days in court. It was held up as the ultimate example of first-world problems being elevated to a legal spectacle, a symbol of a culture overly eager to monetize personal misery. The public largely viewed it as frivolous, an attempt to extract a massive payday for a temporary inconvenience that everyone experiences at some point. The judge overseeing the case clearly agreed with this sentiment, dismissing the lawsuit and likely saving the court from a lengthy trial over the subjective quality of a haircut. The ruling reaffirmed a crucial legal boundary. While consumers absolutely have the right to expect competent service and can sue for a refund or the cost of correction, the law is not a tool for compensating hurt feelings or wounded vanity on a multi-million-dollar scale. The legacy of the bad haircut lawsuit is less about hair and more about the limits of emotional distress claims. It highlights the vast gulf between what we might feel is a life-altering catastrophe and what the legal system defines as a compensable injury. For every successful lawsuit like Stella Liebeck's over third-degree burns, there are countless others like this one that fail because they lack that crucial element of tangible, verifiable harm. It serves as a reminder that the courtroom, while a place for justice, operates on evidence and precedent, not sympathy and subjective outrage. Some problems, even the really frustrating ones, are simply beyond its power to fix. From the frustration of a bad haircut, we move to a problem most people would dream of having: an overwhelming abundance of cash. Our ninth lawsuit takes us into the bizarre and ironic world of the so-called lottery curse, where a windfall of fortune turned into a legal argument for misfortune. In the early 2000s, a man we'll call John, though his identity was often shielded in reports, won a multi-million-dollar prize in his state's lottery. Instead of a story of joy and financial freedom, his tale quickly spiraled into one of familial betrayal, relentless harassment, and profound regret. So profound, in fact, that he decided to sue the very state lottery commission that had awarded him the money, claiming the prize had effectively ruined his life. John's complaint was a detailed chronicle of a dream turned into a nightmare. Almost immediately after his win was made public, he was besieged by a tidal wave of avarice from people he knew and countless strangers. Distant relatives he hadn't spoken to in decades emerged from the woodwork, hands outstretched, often with elaborate and emotionally manipulative sob stories. His home was surrounded by strangers hoping for a handout. His phone rang off the hook with demands, and he faced constant threats and harassment from those who felt entitled to a piece of his pie. The stress, he claimed, led to severe anxiety, sleeplessness, and the complete destruction of his once peaceful private life. His lawsuit argued that the State Lottery Commission was at fault for this chaos because they publicly announced his name and hometown as the winner, thereby painting a target on his back without his consent and without providing any warning or protection from the predictable consequences. The core legal concept the case stumbled over is known as assumption of risk. This principle holds that an individual who voluntarily engages in a potentially dangerous activity cannot later hold others liable for the inherent risks involved. The state's defense was straightforward. By willingly purchasing a lottery ticket, John had implicitly accepted the well-known social realities that come with a highly publicized massive win. The public announcement of winners is not some careless oversight. It is a fundamental and widely publicized part of the lottery's operation. It serves a crucial public interest function by providing transparency and proving to all players that the games are legitimate and that real people actually win the advertised jackpots. The court found that the potential for notoriety and the ensuing public attention were inseparable, foreseeable risks of playing the game, risks that John had willingly taken on the moment he bought his ticket. The irony of the situation was not lost on the judge or the public. Here was a man who had voluntarily entered a contest for a massive monetary prize, won that prize, and was then attempting to sue the contest organizers for giving him exactly what he had asked for. The case was dismissed, with a ruling emphasizing the plaintiff's profound lack of personal accountability. The court effectively stated that the Lottery Commission's job was to administer the game fairly and award the prize money, not to act as a personal security service or life coach for winners struggling to manage their newfound wealth and the attention it brings. The legal system, the judge implied, is not a tool for fixing buyer's remorse, even on a multi-million-dollar scale. This lawsuit sparked a wider cultural conversation that went far beyond the courtroom. It touched on the very real and well-documented psychological phenomenon known as the lottery curse, where sudden wealth leads to depression, isolation, and broken relationships. While the court could offer no legal remedy for this social and personal problem, the case served as a stark public cautionary tale. It highlighted the critical importance of anonymity for winners, a policy some states have since adopted, and underscored the necessity of financial and psychological preparation for anyone who comes into a life-changing sum of money. Ultimately, the case was a powerful lesson that while money can solve many problems, It can also act as a magnet for every hidden crack in a person's life, amplifying existing issues and creating entirely new ones that no amount of cash can easily fix. If you thought suing over lottery winnings was a paradox, our next case presents one that is pure satire, a piece of performance art disguised as a lawsuit that perfectly captured a universal frustration. A few years ago, a man from California grew so weary of the constant nickel and diming from his bank that he decided to fight back in the most unconventional way possible. He didn't file a standard class action suit arguing the fees were excessive or hidden. Instead, he sued his bank for emotional distress, claiming that the automated teller machines failed to display any form of gratitude for his business. His argument was that every time he paid a fee to use an ATM, the machine should, at the very least, display a message thanking him for his patronage. By failing to provide this basic courtesy, the bank had inflicted upon him a profound sense of emotional injury and disrespect. The lawsuit was a masterpiece of absurdist legal critique. It took a mundane, everyday annoyance, those pesky $2 or $3 fees that appear on your statement, and elevated it to a matter of deep personal affront. The plaintiff's filing read like a satirical jab at the entire banking industry, highlighting the one-sided nature of the customer relationship. We give them our money, we pay them fees for the privilege of accessing our own money, and in return, we receive nothing but a cold, impersonal transaction from a machine. The man argued that a simple thank you message programmed into the ATM software would cost the bank virtually nothing, yet would provide a small measure of dignity and recognition for the customer, potentially offsetting the sting of the fee. His claim for damages was not about recouping the fees themselves, but about receiving compensation for the emotional toll of being taken for granted by a faceless financial institution. Unsurprisingly, the court did not spend much time deliberating. The case was dismissed almost immediately, with the judge undoubtedly recognizing it for what it was, a humorous, if pointed, protest rather than a serious legal claim. The ruling reaffirmed that the law deals in concrete harms and enforceable duties. While businesses have a legal duty not to defraud or harm customers, there is no legal statute, common law precedent, or any concept in American jurisprudence that requires a machine or the corporation that operates it to be polite. A fee is a disclosed charge for a service. Whether that service includes good manners is a matter of customer service expectations, not legal liability. But the true victory of this lawsuit was not in the courtroom, it was in the court of public opinion. The story went viral, not because people believed the man had a legitimate legal case, but because they completely understood the sentiment behind it. It resonated with a deep and widespread public frustration over the proliferation of junk fees, those small, often infuriating charges that companies layer on for services that feel like they should be free. The case became a symbol of the everyday power imbalance between large corporations and individual consumers. It was a way of saying, we know these fees are ridiculous and we're tired of it. In that sense, the lawsuit was incredibly effective. It used the platform of the legal system not to win a judgment, but to amplify a message and spark a conversation about fairness, respect, and the often extractive nature of modern consumer finance. It proved that even a frivolous lawsuit can serve a higher purpose, giving a voice, however silly, to a collective groan of annoyance felt by millions. Leaving behind the philosophical debates over gratitude from ATMs, we arrive at a lawsuit that grounds our countdown in a grievance so simple, so fundamentally mundane, that it's almost beautiful in its purity. This is the case of the missing beer. In 2019, a man from Illinois named Daniel T. Doherty decided to file a class action lawsuit against the beer behemoth Anheuser-Busch. His claim was not about false advertising or a defective product in the traditional sense. It was far more straightforward. He had purchased a 6-pack of Beck's beer and upon opening it, discovered it contained only 5 bottles. This omission, he argued, constituted consumer fraud and caused him to suffer real emotional distress. On its face, the case seemed like the ultimate exercise in legal pettiness. The monetary value of the missing beer was negligible, likely less than $2, but Doherty's lawsuit aimed for more than just a replacement bottle. He sought to represent a class of every consumer who had ever been shorted a bottle in a multi-pack, alleging that the brewery was engaged in a systematic money-saving scheme to deliberately underfill its packaging. He claimed the emotional distress stemmed from the feeling of being cheated and deceived by a corporation he had trusted. The public reaction was a predictable mix of laughter and eye-rolling. It was immediately held up as the poster child for frivolous litigation, a perfect example of someone using a sledgehammer of the legal system to crack a very tiny, beer-flavored nut. The case, however, stumbled into a fascinating legal gray area concerning the very definition of fraud. To prove consumer fraud, a plaintiff must generally show that a company made a material misrepresentation that the consumer relied upon, causing a financial loss. The six-pack label and the packaging designed to hold 6 bottles could indeed be interpreted as a representation that 6 bottles were inside. The consumer relies on that representation when making the purchase. The financial loss, while minuscule, was technically real. He paid for 6 units and received 5. By the absolute letter of the law, one could argue a technical violation had occurred. But the legal system is not just about technicalities, it's also about reasonableness, proportionality, and the concept of de minimis non curat lex, a Latin legal maxim meaning, the law does not concern itself with trifles. This is where the case truly fell apart. The court was faced with weighing a microscopic financial injury against the immense resources required to litigate a national class action suit. Discovery would involve subpoenaing production line records, auditing packaging data, and deposing corporate executives, all over a single missing bottle of beer worth pocket change. The judge recognized that while a manufacturing error might have occurred, there was not a shred of evidence to support the claim of a deliberate, fraudulent scheme by the company. A one-off packing error is a quality control issue, not a federal case. The emotional distress claim was dismissed even more swiftly, with the court finding the idea that a missing beer could cause genuine, compensable psychological harm to be utterly without merit and an insult to plaintiffs who suffer actual severe trauma. The lawsuit was dismissed, but its legacy is more than just a joke. It serves as a humorous, almost satirical, highlight of the immense gap between a minor consumer annoyance and the threshold required for judicial intervention. It reminds us that while consumers have a right to get what they pay for, the remedy for a $2 mistake is usually a quick email to customer service for a refund or a coupon, not a multi-million-dollar class action suit. For corporations, it was a reminder that even the smallest packaging errors can potentially land them in court, a testament to the incredible accessibility and occasional absurdity of the American legal system. In the end, the case of the missing beer was less about fraud and more about a fundamental misunderstanding of scale, proving that while you can sue for anything, it doesn't mean you should. While the missing beer case was a dispute over a tangible object, our 12th lawsuit introduces a plaintiff whose grievance was entirely intangible, residing in the interpretation of a sound. This story takes us into the surreal world of a woman who was so convinced of her neighbor's dog's malicious intent that she decided to take the animal itself to court. Her claim was not for a bite or property damage, but for something far more abstract: defamation. She argued that the dog's constant, accusatory barking was a form of slander, deliberately intended to destroy her reputation in the community by making it seem like she was a criminal or a trespasser every time she stepped into her own yard. The legal filing was a masterpiece of misinterpretation, attempting to apply complex human tort law to the instinctual behavior of a pet. Defamation, by its very definition, requires a false statement of fact to be communicated to a third party, causing harm to the subject's reputation. The plaintiff's argument hinged on the idea that the dog's barks were not just noise, but constituted specific, false accusations that her neighbors would understand. She was essentially asking the court to accept that a dog's bark could be translated into a declarative sentence like, "There goes a thief," and that this statement was both knowingly false and made with malicious intent. The case immediately presented a fundamental barrier that goes beyond mere legal technicality and strikes at the very nature of the justice system, the concept of legal personhood. In the eyes of the law, a dog is property. It is a living being with rights against cruelty, but it does not possess the legal capacity to be a party in a lawsuit. It cannot be summoned to court, it cannot understand the charges against it, it cannot secure legal representation, and it certainly cannot form the necessary intent to defame someone. The law deals with the actions of people. If the dog's barking was a genuine nuisance, the case would have been properly filed against the dog's owners for creating a disturbance, not against the animal for its opinions. This lawsuit ignored the human agent entirely, treating the dog as an independent legal actor with its own motives and capacity for malice, a notion that is completely foreign to American jurisprudence. The small claims court judge presiding over the case was reportedly both baffled and amused. Courtroom observers described a scene of utter perplexity as the judge attempted to grapple with the plaintiff's earnest arguments. How does one swear in a canine defendant? How does one establish the meaning behind a series of woofs? The proceeding quickly devolved into a legal impossibility. The judge had no choice but to dismiss the case outright, explaining patiently that the court had no jurisdiction over animals as defendants and that the case, as filed, was not recognized by any statute or precedent. It was a brief, almost whimsical session that highlighted a critical lesson for anyone considering filing suit. A basic understanding of who or what can actually be sued is step one. This case, while hilarious on its surface, underscores a deeper and more serious issue about access to the legal system. Small claims court is designed to be accessible to everyday people without lawyers, handling matters like unpaid debts or minor property disputes. Its accessibility, however, is not a substitute for basic legal literacy. This plaintiff wasted the court's time and resources, and likely her own filing fees, on a claim that was dead on arrival due to a fundamental misunderstanding of a core legal principle. It serves as a perfect, if extreme, cautionary tale. Before you file any lawsuit, it's crucial to ask the most basic questions. Is my grievance against a person or entity that can be held legally responsible? And does the law even recognize the harm I'm claiming? Sometimes the biggest barrier to justice isn't a complex legal doctrine, but the simple, undeniable fact that you can't sue a dog for defamation. After learning you can't successfully sue a dog for defamation, you might think the legal system has firm boundaries, but our 13th case proves that for some plaintiffs, no boundary is too high, not even the atmosphere itself. This brings us to the lawsuit that took aim at the weather, or more precisely, at a television meteorologist. A couple decided to take their local TV weatherman to court after they cancelled a picnic based on his forecast for rain. When the sun shone brightly all day, they felt so aggrieved by their missed opportunity for alfresco dining that they filed suit, seeking financial compensation for their spoiled plans and the emotional distress of a beautiful day wasted indoors. The heart of their grievance was a belief in a kind of contractual guarantee. They had tuned into the news, heard the prediction of precipitation, and made a decision based on that information. When the information proved incorrect, they argued the forecaster and his station were liable for the consequences of their reliance. It was a claim that completely misunderstood the fundamental nature of a weather forecast, treating it not as a well-informed prediction but as a firm promise of future events. The idea that anyone could be held legally responsible for the chaotic and infinitely complex behavior of the global climate system is a notion that stretches the concept of liability to its breaking point and beyond. Fortunately for broadcasters and scientists everywhere, the law is well equipped to handle such creative interpretations of responsibility. Media outlets are protected by a powerful shield, the disclaimer. Almost every single weather broadcast, whether on television, radio, or a weather app, includes a subtle but crucial line of text, often at the bottom of the screen, stating that the forecast is for informational purposes only and is not guaranteed to be accurate. This isn't just a casual suggestion, it's a legally significant disclaimer that forms a critical part of the defense against exactly this type of lawsuit. It explicitly informs the viewer that they are receiving a prediction, not a fact, and that they assume all risk for any decisions they make based on that prediction. Beyond the fine print, this case crashes directly into the pillars of the First Amendment. Weather forecasting, even when conducted by a private television station, is a form of speech. It is the communication of scientific data and interpretation to the public. Holding a meteorologist legally liable for an incorrect prediction would have a catastrophic chilling effect on free speech. Would any forecaster dare to make a prediction if a miss could result in a lawsuit from anyone who changed their plans? The entire practice would grind to a halt, replaced by hopelessly vague and useless statements for fear of legal reprisal. The court recognized that encouraging the free flow of information, even imperfect information, is a paramount public good that far outweighs the disappointment of a cancelled picnic. The judge's dismissal of the case was swift and unequivocal, emphasizing the sheer frivolity of trying to hold a human being accountable for the inherent unpredictability of nature. The ruling underscored that a meteorologist's job is to analyze available data and offer a professional opinion on the most likely outcome, not to control the weather itself. The public reaction to this lawsuit was a mixture of laughter and disbelief, seeing it as the ultimate delegation of personal responsibility. It suggested a world where individuals are merely passive actors, completely absolved from making any decision that carries even the slightest risk of disappointment. This case stands as a monument to a very specific type of folly, the belief that the law exists to insulate us from every minor inconvenience and every dashed expectation, transforming the courtroom from a hall of justice into a complaint department for life's everyday letdown. Leaving behind the unpredictable forces of nature, we arrive at a lawsuit rooted in one of the most personal and profound betrayals possible, the truth of a child's parentage. This case involves a man who, after years of believing he was a father, discovered through a DNA test that he was not the biological parent of his ex-girlfriend's child. Devastated by this revelation, he did not simply walk away. He filed a lawsuit against the child's mother, suing her for the severe emotional distress he suffered, claiming she had intentionally lied to him about the child's paternity for years. The plaintiff's argument was built on a foundation of profound personal trauma. He described investing years of his life, along with significant emotional and financial resources, into raising a child he believed was his own. The relationship with the mother had ended, but he had continued to fulfill what he believed was his moral and legal duty as a father. The DNA test result didn't just end that obligation, it shattered his sense of identity, family, and the very history of his life. His lawsuit alleged that the mother's repeated assurances of his paternity constituted a deliberate and malicious fraud, designed to secure his support and trap him in a parental role under false pretenses. He wasn't suing for unpaid child support. He was suing for the damage to his psyche, for the grief over a lost relationship that was never real to begin with, and for the violation of his right to make informed choices about his life and commitments. This type of case, often referred to as paternity fraud, plunges into incredibly complex legal and ethical territory. On the surface, the man's claim seems to have merit. he was undeniably lied to and suffered a genuine, life-altering injury. However, the legal system struggles to find a clear path to compensation for this specific type of emotional harm. The primary hurdle is the absence of a traditional legal duty. While individuals have a general duty not to intentionally inflict emotional distress on others, courts are extremely reluctant to create a specific legal duty for ex-partners to tell the truth about paternity in the context of a personal relationship. These matters are viewed as intensely private, falling outside the scope of a commercial transaction or a formal contract where fraud is more easily defined. Furthermore, even in the rare instances where a court might acknowledge a theoretical claim, the specter of the child's well-being looms large over the entire proceeding. The law's primary concern in any matter involving a minor is the best interest of the child. Opening the door to lawsuits between parents over paternity truthfulness could potentially harm the child, who is an innocent party in the entire affair. A court would be justifiably hesitant to issue a ruling that might effectively declare a child a fraudulent injury or financially penalize a mother in a way that could indirectly reduce the resources available for the child's care. The emotional bond the man may have formed with the child, which the lawsuit argues was built on a lie, is also considered by the court to be a relationship that had value in itself, further complicating the calculation of damages. For these reasons, most such lawsuits are dismissed. The court typically finds that the injury, while real and deeply painful, is not one for which the law can provide a financial remedy without creating a dangerous and unworkable precedent. The legal system encourages resolved paternity disputes through established family court channels, disestablishing paternity to end future child support obligations rather than through civil suits for emotional damages. This case stands as a heartbreaking example of the limits of the law. It highlights a painful gap where a profound moral wrong exists, but the legal system, bound by precedent and a focus on the welfare of the child, finds itself unable to provide the kind of personal justice the plaintiff so desperately seeks. The courtroom, in the end, can mandate financial support or formalize parental rights, but it cannot truly heal the wound of a stolen parenthood or give back the years built upon a lie. If a wrong weather forecast seems like a stretch for a lawsuit, our 15th case tees up a grievance that is arguably even more detached from reality. It involves a golfer who, after a particularly unfortunate shot, decided to sue the golf course itself. His claim was not about a poorly maintained fairway or a hidden ditch. His opponent was far more elemental, the wind. After he took a swing and a sudden gust blew his ball off course and into a water hazard, he filed a lawsuit arguing that the golf course was negligent for failing to properly weatherproof the area to protect his game from the unpredictable whims of nature. This case immediately plunges into the long-established legal doctrine of assumption of risk, a principle that is particularly robust when it comes to recreational sports. When an individual voluntarily participates in an activity like golf, they are legally understood to be accepting the inherent risks that are an ordinary part of the game. This includes the possibility of erratic weather conditions, from a sudden downpour that soaks a green to a gust of wind that alters a ball's flight path. These are all understood by players to be integral, if frustrating, elements of the sport. The law expects participants to acknowledge that they are playing in an outdoor, natural environment, not a controlled indoor simulator. The golfer's lawsuit attempted to shift this fundamental responsibility, suggesting that the course owners had a duty to engineer a solution, whether through giant wind barriers, netting, or some other technological marvel, to eliminate the natural variable of wind, thereby guaranteeing a perfectly predictable playing experience. The sheer impossibility of the plaintiff's demand is what makes this case so emblematic of legal absurdity. How does one weatherproof several hundred acres of open land? The concept is a practical and financial non-starter. Even if it were possible, it would fundamentally destroy the nature of the game. Golf is, at its heart, a contest of skill played against the challenges of a natural landscape. The rolling hills, the sand traps, the water hazards, and yes, the ever-present wind are not design flaws. They are the essential features of the course. To argue that a course is negligent for having a water hazard is like arguing a ski resort is negligent for having snow. The court recognized that holding a course liable for the effects of weather would set a precedent that would destroy outdoor sports entirely. Could a baseball team sue its stadium because a fly ball was carried over the fence by a gust, turning it into a home run? Could a tennis player sue the tournament organizers because the sun was in her eyes? The logic of the lawsuit, if accepted, would unleash a torrent of equally frivolous claims. One can only imagine the profound exasperation of the judge who received this filing. The dismissal was undoubtedly swift and pointed. The ruling would have reaffirmed that the purpose of the law is to provide remedies for genuine wrongs and preventable harms, not to serve as a safety net for poor luck or a misguided attempt to litigate away every instance of frustration. This case stands as a perfect, almost poetic, example of a plaintiff refusing to accept the basic terms of his chosen activity. It represents a complete outsourcing of personal accountability, where even the forces of nature become someone else's legal responsibility. For the public, it was another hilarious reminder that some people will look anywhere but in the mirror to assign blame, proving that in the game of life you can't sue your way out of a bad lie. But just as the wind on the golf course is an accepted hazard of the game, so too is the unpredictable nature of fan interactions in the world of professional sports. This brings us to our 16th lawsuit, a story that plays out not on the field, but in the chaotic space between an athlete and an adoring fan. A man attending a baseball game managed to get the attention of a famous player, calling out to him and asking for an autograph. According to the lawsuit, the player allegedly nodded in acknowledgement and said he would sign a baseball for the fan after he finished warming up. The fan, elated, waited patiently. But when the player was done, he simply walked back to the dugout, ignoring the fan's continued pleas. Feeling profoundly disrespected and lied to, the fan didn't just boo, he hired a lawyer. He sued the player for breach of an oral contract and for the significant emotional distress caused by the broken promise. At first glance, the fan's claim might resonate with anyone who's ever felt brushed off by someone they admire. There's a sense of a deal being made, a promise given and then reneged upon. But the courtroom isn't a place for hurt feelings over social slights. It's a place for enforcing legally binding agreements. And for any promise to rise to the level of a contract, it must contain a crucial, non-negotiable element known as consideration. Consideration is the legal term for the value exchanged between the parties to a contract. It's what one person gives up or the promise they make in return for the other person's promise. In a standard business deal, consideration is clear. I pay you $50 and you give me a new microwave. Both sides give something of value. In this case, the fan argued that his consideration was his time and his continued presence. He waited patiently instead of leaving or asking someone else. The player's lawyers and ultimately the court saw it very differently. The fan provided nothing of actual legal value to the player in exchange for the promised autograph. His waiting was simply a condition of him receiving the benefit of the player's promise. It wasn't a bargain for exchange. The player received no tangible benefit, suffered no tangible detriment, and gained nothing he didn't already have. This wasn't a commercial transaction. It was a one-sided social promise, the kind people make and break every day without a second thought. The court recognized that to treat every casual, "yeah, sure, I'll get to it later," as a legally binding contract would bring the entire justice system to a grinding halt, buried under an avalanche of trivial grievances. Beyond the cold logic of contract law, there's the immense practical reality of a professional athlete's life. These individuals are constantly surrounded by a vortex of demands from thousands of fans, all shouting, reaching, and asking for a piece of their time and attention. A player might genuinely intend to sign an item after stretching, only to be immediately called away by a coach, reminded of a media obligation, or simply get swept up in the focused mindset required to play a game at the highest level. What seems like a cruel snub to one fan might simply be the reality of an impossibly demanding environment for the player. The law is not designed to micromanage these split-second social interactions or to punish an athlete for failing to follow through on every single casual remark made in a crowded, chaotic stadium. The case was dismissed, and rightly so. The judge's ruling protected a vital boundary in our society: the difference between a legally enforceable agreement and a non-binding social courtesy. To rule otherwise would have created a terrifying precedent. Would every broken dinner plan between friends become a lawsuit? Could you sue a neighbor who promised to help you move and then backed out? The courtroom would become the arbiter of every minor social disappointment, a role it is entirely unequipped and unwilling to fill. This lawsuit, while born from a genuine feeling of letdown, serves as an important lesson in managing expectations. An autograph is a gift, a moment of generosity from a celebrity to a fan. It is not a commodity owed, and a player's vague assurance is not a contract. It's a lesson in understanding that in the whirlwind of professional sports, some promises are meant to be taken with a grain of dirt from the warning track. However, the bizarre legal landscape isn't just about autographs and wind. Sometimes it emerges from the deepest and most sensitive moments of human grief. Our 17th lawsuit takes us into the solemn, heartbreaking world of funeral homes, where a profound and shocking error led to a case that perfectly straddles the line between a legitimate, grievous wrong and a claim that veered into the realm of the unbelievable. A woman arrived at a funeral home to pay her final respects to a dear friend, only to discover that the body in the casket was not her friend at all. The funeral home had mixed up the bodies, and she had just spent an hour mourning a complete stranger. Horrified and traumatized, she did more than complain. She filed a lawsuit against the funeral home for the intense emotional distress she suffered, though the astronomical damages she sought raised more than a few eyebrows. At its core, this case presents one of the clearest examples of a legitimate, legally recognized duty of care. Funeral homes are not like other businesses. They are entrusted with the most sacred of responsibilities, the dignified and correct handling of the deceased. Families and friends are at their most vulnerable, and they place an immense amount of trust in the professionalism of the funeral director. This creates a special relationship that the law takes very seriously. The duty is straightforward: to correctly identify, prepare, and present the designated decedent for services. A mix-up of bodies is not a simple clerical error. It is a catastrophic breach of this fundamental duty that strikes at the very heart of the service they provide. It disrupts the mourning process, creates a nightmarish scenario for all families involved, and inflicts a unique and profound form of psychological trauma on those who have been misled. This is precisely where the legal concept of negligent infliction of emotional distress comes into play, and this case is a textbook scenario for its application. Unlike the bad haircut or the golfer's wind shot, this wasn't a mere disappointment or a frustration. Courts have long held that causing a loved one to suffer a mishandling of their deceased family member can support a claim for emotional damages, even without an accompanying physical injury. The reason is the profound reverence our society places on the proper treatment of the dead and the importance of funeral rites for the living. By causing this woman to engage in a deeply personal and emotional act of mourning directed at the wrong person, the funeral home's negligence fundamentally violated her emotional peace during a period of intense vulnerability. Her distress was a direct, foreseeable, and devastating result of their mistake. Where this particular case arguably drifted from the genuinely tragic into the legally ridiculous was in the scale of damages sought. While the emotional harm was very real, the plaintiff's lawsuit demanded a sum so vast it seemed detached from any reasonable calculation of compensation. It appeared less about making her whole for a specific, quantifiable injury and more about attempting to punish the funeral home with a financial death sentence. This is the realm of punitive damages, which are designed to punish egregious misconduct and deter future behavior, but they must be proportionate to the offense and the defendant's ability to pay. A multi-million-dollar demand from a small, local funeral home for a single, albeit horrific, error can seem more like a seeker of a lottery payout than a seeker of genuine justice. The public perception of this lawsuit was therefore deeply split. Many people understood the sheer horror of the situation and had immense sympathy for the woman's predicament, believing the funeral home deserved to be held fully accountable. Others, however, saw the inflated financial demand as an attempt to monetize grief on an industrial scale, exploiting a terrible mistake to secure a life-changing payday. This tension lies at the heart of many emotional distress cases, the undeniable reality of the harm clashing with the challenge of placing a dollar value on a broken psyche. In the end, cases like these often settle out of court for a confidential sum, as the funeral home has a strong incentive to avoid further scandal, and the plaintiff may wish to avoid a protracted public battle over the price of their grief. This lawsuit remains a powerful example of how a single act of negligence can cause a deep and lasting injury that the law struggles to measure, proving that even the most legitimate claims can be clouded by the pursuit of a remedy that seems to defy all sense of proportion. After confronting the profound distress of a funeral home's error, we shift to a grievance born not from a sacred trust broken, but from the mundane, everyday frustration of waiting. Our 18th lawsuit introduces us to a tenant who decided his landlord was legally responsible for one of urban life's universal annoyances, a painfully slow elevator. This man filed a formal lawsuit not over a lack of heat or a busted lock, but alleging that the building's sluggish elevator caused him severe emotional distress by wasting precious minutes of his life each day and consequently lowering his overall quality of life. The plaintiff's argument attempted to frame a personal irritation as a violation of his right to quiet enjoyment, a fundamental legal concept in landlord-tenant law that guarantees a tenant's right to use their property without unreasonable disturbance. He likely argued that the building's failure to maintain a reasonably efficient elevator constituted a breach of the warranty of habitability, an implied promise that the rental property will be fit for human living. His claim pushed the boundaries of this warranty into entirely new territory. Courts have long recognized habitability to include essential services like functioning plumbing, electricity, heat, and structural safety. A slow elevator, while inconvenient, falls far outside this recognized scope of necessities. No one's health or safety was at risk. The central complaint was an inefficient use of time. The legal system is designed to address genuine harms and material breaches of contract, not to optimize the daily pace of one's life. The judge reviewing this case was faced with the task of drawing a clear line between a legitimate housing complaint and a trivial inconvenience. The ruling would have hinged on the concept of reasonableness. Is it reasonable for a tenant to expect an elevator to operate at a certain speed? While a landlord has a duty to maintain equipment in good working order, they have no duty to ensure it meets a tenant's subjective standard for timeliness. Furthermore, the building's elevator was functioning. It was simply slow. There was no allegation that it was broken, unsafe, or unusable, just that its pace was aggravating. This lawsuit crashed headlong into the legal principle of de minimis non curat lex. The law does not concern itself with trifles. The court's dismissal was a necessary affirmation that judicial resources are precious and must be reserved for resolving substantive disputes involving real injuries or significant breaches of duty. To allow a case over a slow elevator to proceed would open the floodgates to an endless stream of litigation over every minor annoyance of modern living. Could a tenant sue over a noisy pipe, a sticky window, a lobby door that closes too slowly? The legal system would be overwhelmed by a torrent of petty grievances, grinding to a halt under the weight of first-world problems. For the public, this case became an instant symbol of laughable entitlement, the epitome of someone attempting to use the blunt instrument of the law to solve a problem that most people would address with a deep sigh, a change into more comfortable shoes, or simply the use of the stairs. It highlighted a stark contrast between tenants facing genuine, dangerous neglect from their landlords and an individual seeking a legal remedy for a lack of convenience. The case's swift dismissal served as a cultural reminder that while the legal system is a powerful tool for justice, it is not a personal concierge service designed to eliminate life's minor frustrations. Some problems are simply meant to be endured, not litigated. But if the slow elevator case was about a failure of convenience, our 19th lawsuit presents a failure of a very different kind. The failure of random letter generation to account for the English language's vast potential for accidental profanity. This story centers on a driver who received a new license plate from his state's Department of Motor Vehicles, only to discover that the randomly assigned combination of letters, when read in sequence, spelled out a common and highly offensive slang term. Mortified by the public reactions he received, from pointing and laughter to angry gestures, the man decided to sue the DMV. His claim was that by issuing him the plate, the state had inflicted severe emotional distress and publicly humiliated him, effectively forcing him to become a mobile billboard for a vulgarity he never chose. The case immediately plunged into the complex and often contradictory world of the First Amendment. Typically, lawsuits about offensive speech involve the government trying to restrict what a citizen can say. This was the inverse, a citizen arguing that the government, through its own automated speech, had compelled him to display a message that was harmful to his reputation. The man's lawyers likely argued that the DMV had a duty of care to avoid assigning plates that would foreseeably cause this kind of public ridicule, and that their failure to properly screen the random combinations for unfortunate phrases constituted negligence. They were essentially asking the court to make the DMV the arbiter of good taste and the ultimate proofreader for every possible linguistic coincidence. However, the state's defense was built on a foundation of sheer impracticality. License plates are a massive logistical operation. Every year, state DMVs generate and assign millions of new plate combinations through automated systems. To manually screen every single possible alphanumeric sequence for every possible offensive word, acronym, or inside joke in every language and dialect would be a task of unimaginable Sisyphean scale. What might be an innocent word in one language could be a grave insult in another. A sequence that seems fine today might become offensive tomorrow as slang evolves. The court recognized that imposing such a duty on the DMV would bring the entire vehicle registration system to a grinding halt, mired in endless subjective debates over what is or is not appropriate. The system's efficiency relies on randomness, and with randomness comes the occasional, inevitable, and unfortunate alignment of letters. The judge's reaction to the case was reportedly one of bemused sympathy. While acknowledging the man's genuine embarrassment, the court found that his predicament was a matter of personal misfortune, not a legal wrong perpetrated by the state. There was no evidence that the DMV had intentionally targeted him. It was a simple, if spectacularly unlucky, draw. The law deals with intentional torts or proven negligence, not with random acts of linguistic chance. The ruling underscored that the government cannot be held liable for every unfortunate outcome that results from its large-scale, automated administrative functions. The responsibility, the court suggested, ultimately fell on the driver himself. Most states have clear and simple procedures for requesting a new license plate for exactly this reason, often for a minimal fee. His legal remedy was to go back to the DMV and ask for a different combination, not to sue them for the universe's ironic sense of humor. This lawsuit stands as a hilarious example of a plaintiff looking to a higher authority to solve a problem that was well within his own power to fix. It highlights the difference between a genuine grievance against the state and a simple, if deeply annoying, personal inconvenience. For the public, the case was a source of great amusement, a real-life anecdote that seemed too perfectly absurd to be true. It also sparked a wider conversation about the hidden and often hilarious world of vanity plate rejections, where people intentionally try to sneak risque phrases past DMV reviewers. In the end, the case of the offensive license plate was less about free speech and more about personal agency. It was a reminder that sometimes in life, you just get a bad draw, and the appropriate response isn't a lawsuit, it's a trip back to the DMV to try your luck again. Of course, even in the high-stakes world of gambling, some players believe the house isn't the only force working against them. They see an even more ancient and sinister adversary at play, plain old bad luck. This brings us to our 20th lawsuit, a case that pits cold, hard statistics against the deeply human power of superstition. A gambler, after a particularly devastating losing streak at a casino's blackjack table, decided to take his grievance to court. His claim was not that the game was rigged or the dealer was cheating. Instead, he pointed an accusing finger at the number printed on the felt of his table, the number 13. He argued that by seating him at this notoriously unlucky table, the casino had negligently placed him under a curse, thereby directly causing his financial losses and inflicting severe emotional distress. This legal argument required the court to venture into the uncharted territory of supernatural liability. The plaintiff's case was built entirely on the premise that the number 13 possesses an inherent, malevolent power capable of influencing random chance. He likely presented his own deeply held superstitious belief as a factual condition that the casino, as a host, had a duty to accommodate. From his perspective, being assigned to that table was the equivalent of being seated in a chair with a wobbly leg or at a slippery spot on the floor, a known hazard that management should have mitigated. He was essentially asking the judge to issue a ruling that would officially recognize the curse of the number 13 as a legally actionable form of negligence. The casino's defense and ultimately the court's reasoning sliced through this argument with the clean, sharp logic of the law. The core issue was the complete and total absence of any legal duty. A business owner's duty of care is to protect patrons from foreseeable, reasonable harms like wet floors, faulty equipment, or criminal activity on the premises. This duty is grounded in the material world, a world of facts and evidence that can be observed, measured, and proven. A superstition, no matter how widely held or deeply felt, exists in the realm of personal belief. The law cannot and will not compel a business to organize its operations around the infinite variety of individual irrational fears its customers might harbor. Does a hotel have a duty to avoid assigning room 13? Does an airline have a duty to skip row 13? To rule in the gambler's favor would have created a legal nightmare, opening the door to lawsuits from anyone who could connect their misfortune to a broken mirror, a crossed path with a black cat, or an ill-timed walk under a ladder. The judge's dismissal of the case was undoubtedly swift and came with a heavy dose of judicial skepticism. The ruling would have emphasized that gambling, by its very nature, is a pursuit built on risk and random chance. The house always has a mathematical edge, and losses are not just a possibility, they are a statistical probability. The gambler voluntarily chose to play a game of chance, fully aware that the outcome would be determined by the turn of a card, not the number on a table. To blame his losses on a superstitious belief was a clear attempt to evade personal responsibility for the risks he willingly took. The court's message was clear: In a casino, the only verifiable curse is the built-in statistical advantage held by the house, and no lawsuit can provide a magical remedy for bad luck. This case stands as a monument to the limits of legal reasoning when confronted with magical thinking, a reminder that the courtroom deals in facts, not folklore. After confronting the supernatural forces of luck in a casino, we arrive at a lawsuit grounded in a far more earthly and relatable disappointment: the gap between a delicious-looking advertisement and the considerably less impressive reality that arrives at your door. This is the case of the misleading pizza, a classic battle that plays out in courtrooms and living rooms across the country. A customer, feeling cheated after ordering a pizza that looked nothing like the one plastered on the menu board, decided to sue the chain for fraud. His claim was simple: the advertisement showing a pie overflowing with pepperoni and cheese was a deliberate lie designed to trick him into purchasing a significantly less generous product. This case strikes a chord with virtually everyone because it's a universal experience. We've all seen a commercial for a juicy, perfect burger and received a flattened, lukewarm version. We've all admired a picture of a decadent ice cream sundae only to be served a much more modest scoop. The customer's argument taps into a genuine feeling of being duped. He wasn't just complaining about a subjective lack of quality, he was alleging an objective, material misrepresentation. The pizza he received had, for example, perhaps 12 pepperoni, while the advertised pizza appeared to have 30. This, his lawsuit claimed, was not a minor difference in presentation but a quantifiable deception that affected his purchasing decision and caused him a financial loss. He paid for a premium product and received an inferior one. The fate of this lawsuit, and nearly all like it, hinges on a critical legal distinction that governs nearly all advertising: the difference between outright fraud and permissible puffery. Puffery is defined as exaggerated, subjective, or boasting claims that no reasonable consumer would accept as a literal, factual guarantee. It's the kind of sales talk that is understood to be an opinion or an idealized representation. A car commercial showing a vehicle leaping over a canyon is puffery. No one actually believes the family sedan can do that. A pizza chain claiming they have the best pizza in the world is puffery. It's an unverifiable opinion. Courts have consistently ruled that the glamorous, studio-lit, professionally styled images used in advertising are a form of puffery. The perfect cheese pull, the meticulous placement of every topping, the strategic angle that makes the pizza look enormous, these are all understood to be enhancements, the equivalent of a model wearing makeup for a photo shoot. They are selling an aspiration, not a literal blueprint. For a food lawsuit to cross the line from puffery into illegal deception, the misrepresentation usually has to be about something concrete and verifiable that cannot be explained away by the natural variation of a mass-produced product. For instance, if a pizza advertised as having 100% real mozzarella was actually made with a cheese substitute, that would be fraud. If a large pizza was advertised as being 16 inches in diameter but consistently measured only 12 inches, that would be fraud. These are claims about specific, measurable attributes of the product itself. The number of pepperoni, however, falls into a much grayer area. A pizza chain might have a target of 15 pepperoni per pizza, but the automated dispensing machine might occasionally drop 12 or 18. The cheese coverage can vary based on how it's spread. The lawsuit's success would require proving a systemic corporate policy to deliberately and significantly undertop every pizza, which is an almost impossibly high bar to clear. Judges are generally extremely skeptical of these cases, often dismissing them at the earliest possible stage. They recognize that entertaining such claims would unleash a torrent of litigation over every slightly imperfect product. Could a customer sue because their soda had fewer ice cubes than the one in the ad, or because their French fries were less golden? The judicial system would be overwhelmed by a flood of trivial complaints, wasting precious resources on matters that belong in the realm of customer feedback, not federal court. The ruling in the pizza case would have been a firm reaffirmation of the reasonable consumer standard. The court would find that a reasonable person understands that advertising presents a product in its best possible light, and that the actual delivered product may have natural variations. The legal system, in essence, tells us that we have to be smarter than the advertisement. Our remedy for a disappointing pizza isn't a lawsuit. It's a phone call to the manager for a refund or a credit, or simply a decision to take our business elsewhere next time. This case, while born from a relatable annoyance, ultimately serves to reinforce the boundaries of advertiser freedom and consumer common sense, reminding us that the courtroom is not a venue for resolving matters of aesthetic disappointment. But if suing over a pizza's appearance seems like a stretch, our next case takes the idea of misplaced blame to an entirely new level, moving from consumer products into the deeply personal realm of family life. This lawsuit involves a couple who, after following parenting advice from a popular television talk show host, found their household in chaos, alleging that the host's guidance led to severe family discord and psychological harm to their children. The parents filed a lawsuit against the celebrity for giving what they claimed was dangerously bad advice. The scenario is easy to imagine. A family, perhaps struggling with a defiant toddler or a moody teenager, tunes into a charismatic host who dispenses confident, seemingly authoritative guidance on child rearing. The parents, desperate for a solution, implement the suggested strategies, perhaps a strict new disciplinary method or a radical approach to communication. Instead of fostering harmony, the advice backfires spectacularly, leading to increased arguments, resentment, and a fractured relationship with their children. From the parents' perspective, they placed their trust in a public figure presented as an expert, and that trust resulted in direct and devastating harm to their family unit. Their lawsuit argued that the host had a duty to provide sound, reasonable advice and was negligent in promoting techniques that were untested, extreme, or psychologically damaging. This case immediately collides with one of the sturdiest bulwarks of American law, the First Amendment's protection of free speech, particularly the right to express opinions. The courts draw a critical distinction between stating a fact and offering an opinion. A fact is a verifiable statement like, "This medicine contains arsenic." An opinion is a personal view, belief, or recommendation like, "I believe this parenting method is effective." The talk show host's advice fell squarely into the latter category. It was presented as a perspective, a suggested approach among many, not an ironclad guarantee of results. The legal system is fiercely protective of this kind of speech, recognizing that public discourse and the exchange of ideas would grind to a halt if every pundit, commentator, or celebrity could be sued whenever someone acted on their opinion and later regretted it. Furthermore, the lawsuit completely failed to establish the most basic requirement for a negligence claim, a legal duty of care. A duty arises from a specific relationship, like a doctor to a patient or a lawyer to a client. This relationship is built on a foundation of personalized consultation, confidentiality, and a direct understanding of the individual's circumstances. The talk show host had no such relationship with these parents or any viewer. The advice was broadcast to millions of people as general commentary, with no knowledge of any specific family's dynamics, history, or needs. The parents were anonymous members of a vast audience, not individual clients who had retained the host's services. The court found that imposing a duty on every public figure who offers advice would have a catastrophic chilling effect. Dr. Phil, Dr. Oz, financial gurus, and even news commentators would be silenced, too fearful of litigation to share any viewpoint that someone might later blame for a poor outcome. The case was dismissed, and the ruling served as a powerful reaffirmation of personal responsibility. the judge would have emphasized that the ultimate decision to adopt any advice and the responsibility for the consequences of that decision rests solely with the parents. They are the experts on their own children and their own family. Blaming a television personality for a failed parenting strategy is the ultimate abdication of that sacred responsibility. It suggests a desire for a quick, outsourced fix to the complex, nuanced, and deeply personal challenge of raising children, a challenge that no one-size-fits-all television segment can ever hope to solve. This lawsuit stands as a stark reminder that while advice is free for the taking, the responsibility for heeding it is always our own to bear. Having moved from the realm of television advice to the great outdoors, we find our next plaintiff trying to hold a city accountable for one of nature's most unpredictable and fiercely independent creatures, a bird. This lawsuit involves a jogger who was enjoying a run through a public park when he found himself on the receiving end of an unprovoked aerial assault by a protective bird, likely a mockingbird or red-winged blackbird defending its nest. After the shocking and probably quite painful encounter, the jogger didn't just nurse his wounds and tell a funny story, he filed a lawsuit against the city. His claim was that the municipal government was negligent in its wildlife management duties, arguing they had failed to adequately control the animal population or post sufficient warnings about the potential for avian aggression, thereby creating a dangerous public nuisance. The jogger's legal argument attempted to frame a wild animal's instinctual behavior as a failure of civic maintenance, akin to a neglected pothole or a broken sidewalk. He likely argued that the city knew or should have known that certain birds in the park were notoriously territorial during nesting season, and that their failure to act, whether by relocating nests, posting signs, or somehow managing the birds, constituted a breach of their duty to keep public spaces reasonably safe for visitors. On the surface, there's a sliver of logic here. Cities do have a responsibility to address known, recurring dangers. If a particular tree in the park had a large, dead limb that creaked ominously in the wind, and the city ignored repeated requests to remove it, they could be liable if it fell and injured someone. The plaintiff was trying to place a swooping bird into that same category of a foreseeable and preventable hazard. This case, however, immediately smashes into the immovable object of nature's inherent unpredictability and the legal doctrine of assumption of risk. When an individual chooses to engage in an outdoor activity like jogging in a public park, the law understands that they are voluntarily accepting the ordinary risks that are an inseparable part of that natural environment. This includes the possibility of uneven terrain, changing weather, and interactions with wildlife. A bee might sting you, a squirrel might dart across your path, or a bird might decide you've gotten too close to its babies. These are not man-made dangers, they are the fundamental realities of the natural world. The court recognized that holding a city liable for every interaction between a citizen and a wild animal would be an administrative and financial impossibility. It would require municipalities to employ an army of animal behaviorists and park rangers to constantly monitor and manage every squirrel, goose, and sparrow, effectively sterilizing the natural experience these public spaces are meant to provide. The sheer logistical absurdity of the plaintiff's demand is what gives this case its signature tone of comedy. What precisely did he expect the city to do? Issue restraining orders against specific birds, train a squadron of falcons to patrol for overly aggressive songbirds, erect force fields around every nest? The image of a city council holding emergency sessions to debate anti-swooping bird policy is a scene straight out of a satire. The judge reviewing this case was undoubtedly faced with the challenge of maintaining judicial decorum while internally marveling at the creativity of the claim. The dismissal was swift and surely emphasized the fundamental difference between a government's failure to repair its own infrastructure and its inability to micromanage the instincts of every wild creature within its borders. For the public, this lawsuit became an instant classic of legal absurdity. a story that perfectly captures the human tendency to seek an external villain for life's random misfortunes. It's far easier to blame a faceless city government than to accept that sometimes nature is just chaotic and occasionally pecks you on the head. The case serves as a humorous reminder that while we have built complex societies and legal systems, we still share our world with creatures that operate on a completely different set of rules, rules that no municipal code or court order can ever hope to override. In the grand courtroom of nature, the bird's defense is simple and unassailable. It was just being a bird. Yet after contending with the whims of wildlife, our 24th lawsuit takes us into a far more controlled environment, one built entirely on promises and expectations, the packaged vacation. This case centers on a couple who booked a luxury, all-inclusive dream vacation through a travel agency, only to return home feeling profoundly disappointed. The weather was intermittently rainy, a few scheduled tours were overcrowded, and the five-star resort, in their view, felt more like a solid 4. Rather than simply leaving a negative review, they decided to sue the travel agency for breach of contract and emotional distress, arguing that the entire experience failed to live up to the dazzling, sun-drenched fantasy portrayed in the brochures and on the website. The heart of their grievance gets to the very core of how travel is sold. The industry runs on aspiration, using carefully curated photography of flawless beaches, vibrant local culture, and impeccable service. These marketing materials are designed to sell an emotion, a feeling of bliss, escape, and perfection. The couple's lawsuit argued that this marketing wasn't just puffery, it was a tangible part of the contract they entered into. By paying for the dream vacation package, they believed they were purchasing a guaranteed outcome, a specific quality of experience that matched the advertised fantasy. Their emotional disappointment, they claimed, was a direct result of the agency's failure to deliver on that central promise, making it a breach worthy of financial compensation beyond a simple refund. This argument, while emotionally understandable, immediately dissolves under the bright light of contractual law. A travel contract is fundamentally an agreement for specific, concrete services. A flight on these dates, a hotel room of this category, a transfer from this airport. The brochure's gorgeous photos and flowery descriptions of unforgettable sunsets and world-class hospitality are universally treated by courts as classic, non-actionable puffery. They are subjective opinions and marketing hype, not measurable, guaranteeable facts. The court would scrutinize the actual written terms and conditions of the booking, a document that undoubtedly included broad disclaimers acknowledging that factors like weather, crowd sizes, and individual perceptions of quality are beyond the agency's control. The travel agency's legal duty was to provide the listed accommodations and transportation, not to engineer perfect weather or ensure every single guest has an identically magical time. The concept of emotional distress adds another layer of legal impossibility to the claim. Courts are rightly hesitant to award damages for mere disappointment, a feeling that is inherently subjective and impossible to quantify. One person might be deeply distressed by a rainy day on vacation, while another might find it romantic. A family might love a lively, crowded resort, while a couple seeking solitude would despise it. The legal system cannot become the arbiter of vacation satisfaction, weighing the merits of one person's dream against another's. To do so would unleash an unmanageable flood of litigation, with every traveler who had a less-than-perfect trip seeking a financial payout for their dashed expectations. The standard for emotional distress requires a level of severity, like the funeral home mix-up, that far exceeds the common letdown of a marketing fantasy not matching reality. The judge's dismissal of this case served as a crucial lesson in consumer expectations and personal responsibility. It reaffirmed that when we purchase a vacation, we are buying a set of services and a chance at an experience, not a guaranteed emotion. The ruling protects businesses from being held hostage to the infinite variety of human expectation, while also placing the onus on consumers to manage their own fantasies. The true remedy for a vacation that doesn't meet expectations is to provide feedback to the company, adjust future travel plans, or seek a partial refund for any verifiable failures in service delivery, not to demand the courts monetize a subjective feeling of disappointment. This lawsuit stands as a monument to the sometimes painful gap between the lives we see advertised and the lives we actually live, a gap that no legal ruling can ever truly bridge. This next case pulls us from the chaos of public parks and the disappointment of package tours right into the heart of a quintessential suburban conflict, the sounds of children at play. In a quiet residential neighborhood, one homeowner found the joyful shrieks and thunderous footsteps of the kids next door to be an intolerable nuisance, so much so that they filed a formal lawsuit against the family. The plaintiff wasn't alleging property damage or late-night parties. The core of the complaint was the simple, unfiltered noise of childhood itself. The shouting, the laughing, the bouncing of balls, which they claimed constituted a severe disturbance of their peace and quiet, meriting financial compensation. The lawsuit immediately forced the court to wrestle with the fundamental question of what constitutes a reasonable expectation of quiet in a residential community. The law recognizes the right to peaceful enjoyment of one's property, but this right is not absolute. It exists in a delicate balance with the ordinary and necessary activities of daily life. Mowing the lawn, hosting a weekend barbecue, or children playing in their own backyard are all considered reasonable uses of a residential property. The plaintiff was asking the court to make an extraordinary ruling that the natural, daytime noise of children at play was an unreasonable intrusion, akin to the blare of an industrial alarm or the relentless bass of a stereo. This argument required the court to draw a line between a genuine nuisance and the inherent, living sounds of a family-friendly neighborhood. From the perspective of the family being sued, the case felt like a direct assault on their right to exist normally in their own home. They weren't hosting raves, they were raising children. The sounds of play are not just noise, they are the audible evidence of a healthy, active childhood. To penalize a family for this would set a dangerous precedent, potentially criminalizing the very essence of family life in a community. Their defense would have emphasized that the sounds were intermittent, occurred during daylight hours, and were no different from the noises heard in countless other neighborhoods across the country. They were likely to argue that the plaintiff's sensitivity was a personal issue, not a legal wrong perpetrated by their children. Judges are typically deeply skeptical of these cases, and for good reason. The court system is designed to resolve serious disputes involving measurable harms, not to act as a neighborhood referee for minor irritations. The judicial preference in such matters is overwhelmingly for community mediation over litigation. A judge would almost certainly have encouraged the warring neighbors to sit down with a neutral third party to find a compromise, perhaps agreed upon quiet hours or a mutual understanding about the use of certain areas of the yard. This approach acknowledges the interpersonal nature of the conflict. A lawsuit does the opposite. It escalates a minor annoyance into a formal, expensive, and often permanently damaging adversarial battle, turning next-door neighbors into lifelong enemies over an issue that rarely justifies such nuclear options. The predictable outcome for this case was a swift dismissal. The ruling would have firmly reaffirmed that while everyone deserves peace, that peace must be understood within the context of a living, breathing community. The sounds of children playing are not a legal nuisance, they are the soundtrack of a neighborhood. To rule otherwise would be to empower the most sensitive person on the block to dictate how every other family lives, creating a sterile, joyless environment utterly at odds with the purpose of a family home. This lawsuit stands as a stark warning against the overjudicialization of everyday life, a reminder that sometimes the best solution to a problem isn't found in a courtroom, but in a simple, respectful conversation over the backyard fence. Leaving behind the echoing sounds of neighborhood play, we arrive at a case that asks a fundamental question about the most basic of shopping rituals: trying on a pair of shoes. This lawsuit, perhaps one of the most straightforward on our list, involves a customer who purchased a pair of shoes from a store, took them home, and only later decided they were the wrong size. After wearing them and allegedly developing foot pain, he didn't return to the store for an exchange. Instead, he filed a lawsuit against the retailer, claiming the ill-fitting shoes caused him physical injury and significant emotional trauma, demanding compensation far beyond the price of the footwear. The core of his legal argument attempted to place the entire burden of fit on the store. He likely claimed that the sales associate should have been more attentive, that the store's sizing was misleading, or that the shoes were somehow defective. But this case immediately collides with the long-established legal concept of the reasonable consumer and their personal responsibility in a transaction. When you walk into a store, the law generally expects you to be an active participant in your own purchase. For a product like shoes, this means inspecting the item, trying it on for size and comfort, and asking questions if you're unsure. The footwear department isn't a medical clinic. The salesperson is not a podiatrist trained to analyze your gait and pressure points. Their role is to bring you the box you asked for and process the payment. The fundamental duty to ensure the product fits and functions for your needs rests primarily with you, the buyer. This principle is powerfully reinforced by the universal store policy that forms the backbone of retail, the return and exchange policy. Virtually every brick-and-mortar shoe store offers customers a grace period to bring back or exchange unworn merchandise that doesn't fit. This policy isn't just a courtesy. It's a built-in, no-cost safety valve designed specifically to address the exact situation this plaintiff found himself in. His refusal to utilize this simple, standard remedy was a critical failure that severely undermined his lawsuit. The court would see his decision to wear the shoes despite discomfort and then sue, rather than seeking an exchange, as a failure to mitigate his damages, a legal term meaning you have a duty to take reasonable steps to minimize your own losses. By skipping the easy fix, he made his own situation worse, and the law is notoriously unsympathetic to plaintiffs who do that. Where this case truly veered into the territory of the absurd was in the dramatic escalation of the alleged harm. This wasn't just a claim for the cost of the shoes or even for a minor refund. It was a claim for serious physical injury and profound emotional trauma. The leap from a pair of tight shoes to a debilitating foot condition is a vast one that would require extensive, concrete medical evidence directly linking the specific shoes to a specific diagnosable injury. And the claim of emotional distress would be met with even greater judicial skepticism. While the law recognizes severe emotional trauma in contexts like the funeral home mix-up, it does not recognize it for the frustration of a poor purchase. The judge would distinguish between genuine, severe psychological injury and the simple annoyance and buyer's remorse that everyone experiences from time to time. To award damages for emotional trauma here would trivialize the very real suffering of plaintiffs in far more serious cases. The predictable outcome was a swift and decisive dismissal. The ruling would have been a clear affirmation of personal accountability in everyday consumer transactions. It sends a message that the courtroom is not a substitute for common sense or a remedy for a simple mistake that could have been corrected with a 5-minute trip back to the store. This lawsuit stands as a perfect example of the desire to completely outsource responsibility, to transform a minor personal oversight into a major legal battle with a corporation. It reminds us that while consumer protection laws are vital for guarding against genuine fraud and dangerous products, they are not designed to protect us from the consequences of our own inattention. Sometimes a wrong size is just a wrong size, and the solution is a receipt and a return desk, not a complaint filed with the court. Yet even a lawsuit over noisy children requires a tangible defendant, a neighbor, a city, a corporation. Our 27th case, however, ventures once more into the ethereal, seeking to hold the cosmos itself, or at least one of its earthly interpreters, legally accountable. This story involves a woman who, after experiencing a series of personal and professional setbacks, decided to trace her misfortune back to a single, seemingly innocuous source, her daily horoscope. She filed a lawsuit against a newspaper and the columnist who wrote the astrology section, claiming that the predictions published were so egregiously inaccurate that she had relied on them to make catastrophic life decisions, leading to financial loss and severe emotional distress. Her claim was built on a foundation of profound regret. She might have described how a horoscope predicting a financially fortuitous day led her to make a risky investment that promptly collapsed. Perhaps a forecast of romantic harmony convinced her to confront a partner in a way that backfired spectacularly, ending the relationship. In her mind, the newspaper wasn't just publishing harmless entertainment, it was dispensing specific, actionable guidance that she had accepted in good faith. Her lawsuit attempted to frame the relationship between columnist and reader as one akin to that of a financial advisor and client or a doctor and patient, where a duty of care and accuracy is legally implied. She was arguing, in essence, that the horoscope section should be held to the same standard of truth as the front-page news. This argument immediately unravels when examined under the light of both law and common sense. The defense and the court would immediately focus on the concept of fiduciary duty, a special legal obligation to act in someone else's best interest, requiring the highest degree of good faith and trust. This duty exists in specific, recognized relationships: lawyers to clients, trustees to beneficiaries, stockbrokers to investors. A newspaper columnist writing a mass-produced, generalized horoscope for millions of anonymous readers has no such relationship with any individual. The court would find that no reasonable person could possibly interpret a 3-sentence blurb in the entertainment section as a personalized, professional consultation upon which to base life-altering decisions. The horoscope is presented and understood as a form of play, a speculative diversion, not a blueprint for living. The case would have been met with barely contained laughter in the courtroom, not out of cruelty, but from the sheer absurdity of its premise. The judge would have been tasked with the impossible job of evaluating the accuracy of astrological predictions. What would the standard of proof be? Would the court need to call expert witnesses in astronomy and astrology to debate the position of the planets on a given day and their alleged influence on human affairs? The very idea is a judicial non-starter, plunging the courtroom into a realm of metaphysical speculation it is entirely unequipped to handle. The First Amendment's protection of free speech provides a sturdy shield, protecting the columnist's right to publish opinions, fantasies, and entertainment, especially if they are divorced from factual reality. The dismissal of this case was a foregone conclusion, a swift and definitive ruling that served to protect the vital distinction between fact and fantasy in public discourse. For the public, it became another uproarious example of a plaintiff refusing to take ownership of their own choices. It's far easier to blame the stars or a newspaper's interpretation of them than to accept that our own misjudgments are the primary architects of our misfortune. This lawsuit stands as a monument to the human desire for a simple, external explanation for life's complexities. But the courtroom is a place for evidence and reason, not for seeking cosmic justice for a bad prediction. The legal system, in the end, can offer no remedy for a failure to distinguish between celestial guidance and a bit of daily fun. But if astrological guidance proves to be a flimsy foundation for a lawsuit, our next case reveals a plaintiff who believed he had a rock-solid legal claim over something even more transient, an empty parking space. This lawsuit takes us to a crowded urban center where the battle for a coveted spot escalated from a frustrating exchange of honks and gestures into a full-blown legal filing. One driver, after patiently waiting with his turn signal on for a car to vacate a public parking space, watched in fury as another motorist swooped in and claimed the spot. Incensed, the first driver didn't just lean on his horn. He later filed a lawsuit against the thief, alleging the intentional infliction of emotional distress. The plaintiff's argument was built on a sense of violated fairness, a deeply held belief in an unwritten rule of urban driving etiquette: the person who waits first gets the spot. He likely described the visceral anger and sense of powerlessness he felt, arguing that the other driver's actions were not just rude but were calculated to cause him maximum psychological harm. His lawsuit attempted to frame this everyday act of vehicular opportunism as a deliberate tort, a malicious act designed to trigger emotional distress. In his view, the other motorist had seen his clear intention to park, had recognized his distress, and had chosen to proceed anyway, making the act one of intentional cruelty rather than simple competition. This case, however, immediately crashed into the immovable object of property law. The fundamental flaw in the lawsuit was the plaintiff's mistaken belief that he could possess a right to a public parking space. Public streets are just that, public. They are owned by the city or the state for the use and benefit of all citizens. No individual can claim a proprietary interest in a specific 10 by 20 foot rectangle of asphalt simply by signaling their desire for it. Ownership, or the right to exclusive use, is only transferred through a specific, legally recognized mechanism, like a lease or a purchase. A driver waiting for a spot has no more legal claim to it than a person eyeing an empty bench in a public park has a right to prevent someone else from sitting there. The space belongs to everyone and therefore to no one in particular until a vehicle is physically and legally parked within it. The legal concept of intentional infliction of emotional distress is an extraordinarily high bar to clear, and this case didn't even come close. To succeed, a plaintiff must prove that the defendant's conduct was so extreme and outrageous that it goes beyond all possible bounds of decency and is utterly intolerable in a civilized community. It is conduct that is more than just illegal, annoying, or rude. It is truly shocking. While stealing a parking space might feel outrageous in the heat of the moment, it is a commonplace annoyance in city life, not an act that would cause a reasonable person to suffer severe emotional trauma. The court would distinguish sharply between genuine, devastating psychological injury, such as that caused by the funeral home's negligence, and the temporary anger and frustration of a minor traffic dispute. The law expects adults to possess a certain resilience to the ordinary slights and irritations of daily life. Unsurprisingly, the judge's dismissal of this case was both swift and likely accompanied by a measure of judicial exasperation. The ruling would have served as a blunt lesson in legal realism, reinforcing that the courtroom is not a venue for resolving interpersonal squabbles or punishing simple discourtesy. To allow such a suit to proceed would set a catastrophic precedent, inviting a tidal wave of litigation over every minor social infraction. Could a shopper sue another for taking the last carton of milk? Could a commuter sue for a jostle on a crowded train? The very purpose of the judicial system is to resolve serious disputes, not to micromanage petty conflicts. This lawsuit stands as the ultimate example of the desire to weaponize the law against everyday annoyances, a futile attempt to seek a legal remedy for a problem that is, and always will be, a simple matter of bad manners. But if the battle over a parking spot represents a conflict over physical space, our next lawsuit plunges us into the digital arena, where a single negative opinion can spiral into an all-out legal war. This brings us to the case of the bad review retaliation suit, a modern legal phenomenon where a business, stung by a customer's critical online post, decides to fight back not with improved service but with a lawsuit. The scenario is increasingly common. A customer has a poor experience at a restaurant, a hotel, or with a local contractor. They go home and vent their frustrations on platforms like Yelp, Google, or TripAdvisor, writing a review that details their dissatisfaction. The business owner, seeing this public critique as a direct threat to their livelihood, responds by filing a defamation lawsuit against the customer, claiming the review is filled with false statements of fact that have caused a quantifiable loss of income. These cases force the courtroom to perform a delicate balancing act between two fundamental rights: the right of a business to protect its reputation from malicious falsehoods, and the right of a consumer to share their honest opinions and experiences. Defamation law requires the plaintiff, in this case the business, to prove that the defendant made a false statement of fact, not an opinion, to a third party, and did so with a certain degree of fault, usually negligence or actual malice, which then caused a measurable financial injury. The business must show that the review crossed the line from subjective critique: the service was slow, the food was overcooked, I found the owner rude, into the realm of objectively verifiable falsehood, such as this restaurant serves expired meat, or this contractor has no license, when in fact they do. The problem for businesses is that this legal line is incredibly difficult to cross. Courts have consistently and vigorously protected hyperbolic expressions of opinion under the First Amendment. A statement like, "This is the worst hotel I've ever stayed in," is pure opinion. It cannot be proven true or false. Even a more specific claim like, "I found a hair in my food," is a statement of the customer's personal experience, which is exceedingly difficult for a business to disprove after the fact. Unless a business can obtain clear and convincing evidence that a review was written with actual malice, that is, with the knowledge that it was false, or with reckless disregard for the truth, the lawsuit is almost certainly doomed to fail. This high bar exists for a crucial reason. The law values open public discourse and the ability of consumers to share information, even when that information is harshly critical. This is where these lawsuits often trigger a spectacular and ironic backfire known as the Strace and effect. The term was coined after singer Barbra Strace and attempted to suppress photographs of her Malibu home, an action that inadvertently drew far more public attention to the images than they ever would have received otherwise. In the context of a bad review lawsuit, the business's attempt to silence a single critic almost always backfires catastrophically. The act of suing a customer is itself a news story and rarely a flattering one. The original negative review, which might have been seen by a few dozen people, suddenly goes viral, being shared across social media and reported on by news outlets. The court filings, which become public record, often contain the business's own unflattering characterization of the event and the customer. The ensuing public backlash can be devastating, leading to a torrent of new one-star reviews from people who have never even visited the business, but who vehemently oppose what they see as a bullying tactic to suppress free speech. The lawsuit, intended to repair a reputation, often ends up shredding it beyond recognition. Beyond the public relations nightmare, these suits present a profound practical miscalculation. The financial cost of litigation, even for a strong case, is immense. For a small business, the legal fees alone can be crippling. Furthermore, the time, energy, and emotional toll spent battling a former customer in court is a massive distraction from the actual work of running and improving the business. Instead of addressing the underlying service issue that prompted the review, the owner becomes consumed with a bitter legal fight. The smarter, more effective strategy is almost always to engage directly with the criticism. A professional, empathetic public response to a negative review, apologizing for the bad experience, explaining any misunderstandings, and perhaps offering to make it right, can actually enhance a business's reputation. It demonstrates to all potential customers that the management is attentive, cares about customer satisfaction, and is committed to improvement. A lawsuit, by contrast, signals the opposite, that the business is defensive, combative, and unwilling to listen. In the court of public opinion, the gavel comes down hard, and the sentence is often a devastating and permanent loss of goodwill. But if the act of leaving a negative review can land a customer in court, our next lawsuit reveals a plaintiff who believed his rights were violated not by a critique he wrote, but by the programming he watched. This case centers on a television viewer who grew so utterly fed up with the commercial breaks interrupting his favorite primetime drama that he decided to take drastic action. He filed a lawsuit against the broadcast network, arguing that the sheer volume of advertisements constituted a breach of contract and a violation of his rights as a consumer. His claim suggested that by saturating the hour-long time slot with commercials, the network had effectively failed to deliver the full amount of entertainment programming he felt he was owed. This viewer's grievance taps into a nearly universal frustration. We've all settled in to watch a highly anticipated episode, only to be pulled out of the narrative every few minutes by a loud, jarring block of ads for cars, insurance, and snack foods. His legal argument attempted to frame this annoyance as a quantifiable financial injury. He likely argued that his implicit contract with the network, a contract formed by his act of tuning in, was for a certain amount of show and a reasonable amount of ads. By exceeding this unwritten threshold, the network had, in his view, provided a defective product, much like a bag of chips that is mostly air. He was suing for the value of his lost time and the degradation of his viewing experience. However, this argument immediately collides with the clear and established regulations set forth by the Federal Communications Commission, the government body that oversees broadcast television. The FCC actually does have rules governing commercial time, known as commercial limits. These rules are designed to prevent egregious abuse and ensure a baseline of programming integrity. For example, during primetime hours, which are between 8 and 11 p.m., networks are generally allowed a maximum of 9.5 minutes of commercials per hour. During children's programming, the rules are even stricter. The network's defense would have been a simple matter of compliance. They could present their programming logs to the court, demonstrating that their ad breaks, while numerous, fell squarely within the federally mandated limits. The viewer's subjective feeling of being overwhelmed by ads was not a legal violation if the network was playing by the government's own rules. The case then stumbles over a second, even more fundamental legal barrier, the concept of standing. In order to sue someone, you must have standing, meaning you must have suffered a concrete and particularized injury that the court can address. A vague feeling of annoyance and impatience does not qualify as a legally recognizable injury. Furthermore, the FCC's commercial limits are not designed to protect the individual sensitivities of each viewer. They are created to serve the public interest as a whole. The mechanism for complaining about a broadcaster violating these rules is to file a complaint with the FCC itself, which can then investigate and potentially levy fines against the network. The law does not provide for individual viewers to sue for monetary damages every time they feel a commercial break has dragged on too long. The court would find that this viewer lacked any legal standing to bring this case as an individual lawsuit. Beneath the legal technicalities lies a profound and almost willful misunderstanding of the entire economic model of free, over-the-air broadcast television. The plaintiff was essentially demanding a premium, ad-free experience while paying absolutely nothing for it. Broadcast television is not a public utility, it is a business. The production of those high-budget primetime shows costs many millions of dollars per episode. The entire system is funded exclusively by advertising revenue. Those commercials aren't an intrusion on the product, they are the product. The actual show is the bait that gathers a large audience, which is then sold to advertisers. This is the foundational bargain of free TV. You exchange your time and attention for entertainment without ever opening your wallet. To sue over the very mechanism that makes the entire system possible is to reveal a baffling lack of understanding of how the media world functions. The judge's dismissal of this case was a foregone conclusion, a swift and definitive ruling that upheld the basic economic realities of broadcasting. It served as a blunt reminder that the courtroom is not a feedback form for consumer preferences. If a viewer is truly dissatisfied with the ad load on network television, their recourse is not a lawsuit. It's to change the channel, invest in a digital video recorder to skip the ads, or subscribe to a premium, ad-free streaming service. This lawsuit stands as the ultimate expression of a desire for something for nothing, a legal fantasy where one could enjoy the fruits of a commercial enterprise without accepting the commercial itself. It was a case that ignored the fundamental deal we all make when we turn on the TV for free. The shows are the gift and the commercials are the price tag. Moving from the structural certainties of broadcast advertising, we arrive at a case built on a foundation of pure what-if, a legal argument that hinges entirely on a reality that never was. Our 31st lawsuit takes us into the realm of a staggering near miss, where a man's own carelessness led him to demand a fortune from a convenience store clerk. The story begins with a man purchasing a lottery ticket from his local store, a routine act of hope repeated millions of times a day. Later, he became convinced that this specific ticket was the sole winner of a multi-million-dollar jackpot. There was just one catastrophic problem: he had lost it. Unable to produce the ticket, he did the only thing he felt he could. He sued the store, demanding they pay him the entire jackpot amount he believed was rightfully his. His claim was a fascinating, if flawed, exercise in shifting responsibility. He likely argued that the store, as the agent of the lottery, had some ongoing duty to him even after the transaction was complete. Perhaps he suggested their verification systems were inadequate, or that they should have a better method for tracking who buys which ticket. At its heart, his lawsuit was a desperate attempt to bypass the most fundamental, non-negotiable rule of the lottery. The ticket itself is the one and only key to the kingdom. It is not a receipt for a purchase, it is the literal bearer instrument that constitutes proof of ownership. Without it, you do not have a claim, you have a story. The store's defense was unshakable because it was built on the bedrock of the lottery's own published rules. Every single payslip, every terminal, every TICKET Chinese letter explicitly states that the Lottery Corporation is not responsible for lost, stolen, or damaged tickets. The ticket is the property of the purchaser upon sale, and with that property comes 100% of the responsibility for its safekeeping. The store's duty begins and ends at the point of sale, to correctly enter the numbers selected by the customer and to provide the corresponding correctly printed ticket. Once that ticket is handed over the counter, the store's contractual and legal obligation is completely fulfilled. They become a disinterested third party. To hold them liable for a customer's subsequent loss would be to impose a perpetual, impossible duty of care over an item they no longer possess or control. The case presented the court with an epistemological nightmare. How does one prove the existence and contents of something that is gone? The plaintiff's belief, no matter how fervent, was not evidence. He could not provide the serial number, the time of purchase, or any verifiable detail that could be cross-referenced with the lottery's central computer to confirm his story. For all the court knew, he could have been mistaken about the numbers, or the ticket might have been a loser. The legal system operates on evidence, not on heartfelt conviction. Awarding him the jackpot would have required the judge to make a multi-million-dollar leap of faith, an act of judicial creation that would have demolished the entire operational integrity of the state lottery system. The precedent would have been catastrophic, inviting a wave of copycat lawsuits from anyone who ever misplaced a ticket and later decided it must have been a winner. The judge's dismissal was not merely a rejection of a claim, it was a reaffirmation of a core principle of personal responsibility. The ruling underscored that the law exists to protect rights and remedy wrongs, not to indemnify individuals against their own mistakes. The heartbreaking irony of the situation was not lost on anyone, a man who may have indeed held fortune in his hand, only to let it slip away through his own error. Yet the courtroom cannot be a place where we are saved from our own carelessness. This lawsuit stands as a summer lesson in the harsh, unforgiving logic of chance and contract, where a dream is nothing more than a worthless piece of paper until you can actually produce it and prove it's real. Yet after confronting the loss of a lottery ticket, a mere slip of paper, we arrive at a lawsuit that challenges the very essence of human connection and the promises we make to one another. Our 32nd case is perhaps one of the most ethically offensive on our list, a story so shocking it sounds like a dark joke, the lawsuit of the ugly baby. A man, upon the birth of his child, was so disappointed with the infant's appearance that he filed a lawsuit against his own wife. His claim was a masterpiece of misogynistic absurdity, alleging that she had committed fraud by misrepresenting her own beauty before their marriage, thereby tricking him into fathering a child he found aesthetically displeasing and causing him profound emotional distress. The husband's legal argument was built on a foundation that completely reduces a person to their physical appearance and reduces marriage to a transactional contract based on superficial guarantees. He treated his wife's face and form not as a natural, changing aspect of a human being, but as a warranty-backed product feature. In his twisted logic, by using makeup, choosing flattering angles in photographs, or perhaps even just by aging naturally, she had engaged in a deliberate bait and switch, delivering a child that did not meet the specifications he believed he had signed up for. This case completely ignores the fundamental purpose of marriage as a partnership built on love, commitment, and mutual support, reframing it instead as a cold business deal where one party is liable for failing to deliver a genetically predetermined standard of attractiveness. This lawsuit crashes headlong into the basic, beautiful chaos of human genetics. The blending of DNA from two parents is the ultimate genetic lottery, a complex and unpredictable process that can result in a child bearing a strong resemblance to one parent, a mix of both, or sometimes surprising traits from generations past. A child might have their mother's eyes but their grandfather's nose, or a unique combination that is entirely their own. To hold a parent responsible for the outcome of this natural, random process is not just legally frivolous, it is a profound misunderstanding of biology itself. The court would be asked to rule on the unrulable, to assign blame for a process that science itself cannot perfectly predict or control, making the case a scientific as well as a legal impossibility. Beyond the genetics, the ethical offensiveness of this claim is staggering. It treats a newborn child not as a person to be loved and cherished, but as a defective product that failed a quality inspection. The very act of litigating a child's appearance risks inflicting untold psychological damage on that child in the future, should they ever learn that their own parents sought a court's validation for their rejection. The case also places the entire burden of a child's looks on the mother, a toxic and archaic notion that ignores the father's equal genetic contribution. It weaponizes the law to enforce a cruel, shallow, and utterly subjective standard of beauty upon the most vulnerable of human beings. Unsurprisingly, the court's response was one of swift and unequivocal moral condemnation. The judge's dismissal was likely a powerful rebuke, emphasizing that the legal system exists to protect citizens from genuine harm, not to adjudicate matters of personal vanity or subjective disappointment. The ruling would have firmly reaffirmed that a child is a blessing, not a commodity, and that parental love is an unconditional duty, not a conditional reward based on aesthetics. To entertain such a suit would have set a dangerous and dehumanizing precedent, potentially opening the door to lawsuits over a child's height, intelligence, or athletic ability, reducing human reproduction to a mere transaction with legally enforceable warranties. This case stands as a chilling reminder of the extremes of vanity and entitlement, a testament to how far some will go to avoid personal responsibility and project their own shallow disappointments onto others through the blunt instrument of the law. And so we arrive at the final, and perhaps most audacious, case on our countdown, a lawsuit that so perfectly inverts the concepts of blame and responsibility, that it stands as the ultimate crescendo of legal absurdity. This is the story of the self-surgery malpractice suit, a case where a patient's extreme act of self-determination led directly to a catastrophic outcome, which they then attempted to blame on the very medical professional who had tried to prevent it. The facts are as shocking as they are clear. A patient required a relatively minor but technically precise surgical procedure. The surgeon, following every standard of medical ethics, thoroughly explained the risks, benefits, and alternatives, obtained the patient's informed consent, and scheduled the operation. However, just before the procedure was to begin, the patient made a stunning demand. They wanted to perform the surgery themselves. They insisted they had researched it extensively online, understood the process perfectly, and believed they had a steadier hand. The surgeon, of course, refused outright, explaining the immense dangers of such an action and reaffirming that it was a clear and gross violation of medical ethics, hospital policy, and basic common sense. The patient was undeterred. Against all medical advice, they acquired the necessary instruments and attempted the procedure on their own at home. The result was precisely what any reasonable person would predict: a severe infection, significant tissue damage, and life-threatening complications that required emergency intervention to correct. Here is where the story accelerates from a tale of shocking recklessness into the stratosphere of legal fantasy. After being stabilized by the very medical system they had spurned, the patient filed a malpractice lawsuit against the original surgeon. Their claim was a breathtaking masterpiece of misplaced blame. They argued that the surgeon had failed in their duty of care by not stopping them more forcefully. They alleged that the pre-operative consent process had been inadequate because it didn't specifically warn them against the dangers of self-surgery, and that the doctor's refusal to hand over the scalpel and supervise constituted a form of patient abandonment. In their mind, the surgeon's professional responsibility was so absolute that it extended to preventing them from their own disastrously stupid decisions, even when those decisions were made in direct defiance of expert counsel. This case forces the courtroom to grapple with the outermost limits of two foundational medical legal principles: informed consent and patient autonomy. Informed consent is the doctrine that a patient must be presented with all relevant information about a treatment to make a knowledgeable decision about their own body. The surgeon in this case had unquestionably fulfilled this duty regarding the procedure he was to perform, but the patient's lawsuit attempted to expand this duty into the absurd, suggesting a physician must also inform a patient of the dangers of every conceivable alternative, including wildly dangerous and illegal actions that no reasonable medical professional would ever contemplate. The court swiftly rejected this notion, affirming that the duty of informed consent is tethered to the standard of care within the medical community, not to the infinite universe of a patient's personal whims. Patient autonomy, the right of a person to control what happens to their own body, is a sacred principle in medicine and law, but it is not an unlimited right. It exists in a careful balance with the principle of non-maleficence, a doctor's duty to do no harm. A surgeon's license and oath are not simply tools to be placed in a patient's hand upon request. The patient's demand asked the court to compel a professional to become a silent accomplice to an act they knew would cause grievous harm, effectively making the surgeon an instrument of the patient's own self-destruction. The court's ruling was a powerful defense of professional integrity, stating unequivocally that a doctor's ethical and legal duty to refuse participation in a harmful act trumps a patient's autonomous demand for that participation. A patient has the autonomy to refuse treatment, even to their own detriment, but they do not have the autonomy to force a licensed professional to enable their own suicide or mutilation. The judge's dismissal of the lawsuit was not just a legal ruling, it was a robust affirmation of personal accountability. The court found that the chain of causation, the direct link between the doctor's actions and the patient's injury, was severed the moment the patient consciously and recklessly decided to act against explicit expert advice. The surgeon's refusal to enable the self-surgery was not the cause of the harm. It was the only ethically correct action in a sea of bad choices. The cause of the harm was purely and simply the patient's own hand. This case stands as the final, perfect bookend to our journey through American legal absurdity. It showcases a plaintiff who, after being presented with expert guidance, choosing to ignore it in the most dramatic way possible, and suffering the entirely predictable consequences, looked anywhere but in the mirror to assign blame. It is a testament to the sheer audacity of attempting to outsource the responsibility for one's own most reckless actions, and a comforting reminder that even in a system known for its astonishing cases, there are still some lines that cannot be crossed. And so, after this wild tour through 33 of the most mind-bending legal battles ever filed, what are we left with? A collection of stories that, at first glance, seem to confirm every stereotype about a lawsuit-happy culture gone completely off the rails. From suing over the temperature of coffee to taking on the government for failing to stop alien abductions, these cases push the boundaries of logic, reason, and sometimes even reality itself. They are a testament to the incredible creativity, or perhaps unbridled madness, that can flourish when the courtroom doors are open to almost any grievance, no matter how trivial or fantastical. Yet, to dismiss them all as mere jokes would be to miss the profound and often troubling truths they reveal about the American legal system and our society itself. For every truly frivolous case like the golfer suing the wind, there is a more complex one like the McDonald's hot coffee suit, which was widely mocked but upon closer inspection revealed a powerful story of corporate negligence and a jury delivering a staggering punitive award to send a message. These cases exist on a spectrum. Some highlight the very real need for tort reform to prevent the judicial system from being clogged with petty, vindictive, or purely fantastical claims that waste everyone's time and resources. Others, however, remind us that the right to a jury trial is a crucial check on power, allowing ordinary citizens to challenge massive corporations and institutions, even if their methods sometimes seem unorthodox. What truly unites these stories is their powerful effect on public perception. They shape how we view justice, responsibility, and blame. They fuel debates about personal accountability versus corporate duty. They make us ask where we draw the line between a legitimate claim for compensation and an attempt to monetize simple misfortune or one's own poor choices. These cases, whether laughed out of court or settled behind closed doors, become cultural touchstones. They are discussed at dinner tables, debated on news programs, and used as cautionary tales or rallying cries in the ongoing conversation about what fairness really looks like in a modern, complex world. Ultimately, the most important lesson from this bizarre legal journey might be the simplest one: the indispensable value of common sense. The law provides a framework, but it cannot account for every absurdity the human mind can conceive. It falls to judges, juries, and society as a whole to apply a filter of reason, to distinguish between a genuine plea for justice and a fanciful flight from responsibility. These 33 cases serve as a permanent and often hilarious reminder that while the law is a powerful tool for order, it is not a substitute for wisdom, personal accountability, or the basic understanding that sometimes life is just unfair, unpredictable, and occasionally downright ridiculous. Now we want to hear from you. Did we miss a famously absurd lawsuit that you think deserves an honorary spot on this list? Maybe you've heard a local legend about a neighbor who tried to sue over a noisy squirrel, or a story that perfectly captures the spirit of legal creativity gone awry. Share your own favorite ridiculous lawsuit stories down in the comments below. Let's keep this conversation going. And if you enjoyed this dive into the stranger side of American justice, make sure to hit that subscribe button and ring the notification bell. We're always exploring the most fascinating, unbelievable, and bizarre facts about America, and we can't wait to share the next chapter with you. Thanks for watching.